Good morning, all. Are we not starting at 9?
Good morning, members. Good morning, everyone. No, Mama, it's 9:30. Thank you.
Yeah, and we see that the meeting started at 9. That's why we logged in so early. So it's 30 minutes earlier that we logged in.
Good morning. Good morning, everybody. So you're saying we're starting at 9:30, not 9 o'clock, no?
Good morning. Yes, DM, it's 9:30, not 9. Thank you.
So I can log out now.
For a few minutes, yes, DM.
Thank you.
Recording in progress. Recording stopped. Recording in progress. Recording stopped. Recording in progress. Recording stopped.
So we are starting now at 10 and not 9:30. Thank you.
No, we're starting at 9:30, not at 10. Good morning, members, and good morning, Member Adams.
Good morning. It's already 9:30.
Hello, honorable members. Hello, honorable members.
Hello, yes.
Good morning, Chairperson.
Chair.
Good morning, honorable members. Good morning, everybody. We are struggling a bit, but we are going to be okay very soon. Yeah. Well, I hope we are correcting now. Is the secretariat there? Cynthia, are we now correcting?
Yes, Chair, we do have a quorum. Thanks.
Okay, thank you. Once again, good morning, honorable members. Good morning, the minister and his team. And good morning, the acting DG and her team. I wonder if we could actually look at the agenda. Our meeting is on Zoom, as you can always obviously see, and that we have a few, items, the consideration of and adoption of the budget votes. It's not in any particular order. Briefing by the department on CPA complaints, and we will also be looking at the outstanding minutes. So I wonder if before we adopt the agenda, can we actually look at the apologies if there are any?
Good morning.
Yeah.
Good morning, members. Yes, we do have an apology from the minister. The email I received last night, he says he has an international commitment. I'm trying to go to the letter to read the letter. He's attending an international commitment on government business, the sixth AU/EU Agriculture Ministerial Conference, which is from the 27th of June 2025, and the 44th FAO Conference from 28th June to 4 July 2025 in Rome. Thanks, Chair.
Thank you. Do we have the Deputy Minister in the meeting? Therefore, if the Minister is not there.
Yes, good morning, Chairperson. I am indeed in the meeting.
Oh, thank you. Thank you, Honorable Deputy Minister. Thank you. I'm seeing a hand. I think it's Honorable Andile's phone.
I think it's Honorable Ngitama, Chair.
Okay, Honorable Ngitama.
Thanks, Chair. I just want to register an apology for Honorable Madlala.
Oh, okay. Okay. Thank you. Apologies having actually been registered. can we look
Chair,
at the yes?
Chair, sorry, I apologize. I'm attending my daughter's in hospital, but I will log in while the doctor's still not here. But I will log in.
Okay, okay, no, we understand. All right, thank you. Okay, can we look at the agenda for possible adoption or addition and adoption? Is there any mover of the adoption of our agenda?
Recording in progress.
Is there any mover? Honorable members, I don't see a hand.
Good morning, Chair.
Good morning, Chair. Chairperson, I move.
Can you identify yourself, honorable member?
Honorable Chairperson is Honorable Van Wyk, yeah.
Oh, thank you, Honorable Van Wyk. The Honorable Van Wyk is moving for the adoption of the agenda. Any seconder?
Good morning, Honorable Chair. Mkhaga seconds.
Oh, thank you, Honorable Mkhaga. I would suggest that we start by getting a briefing by the department on the CPA complaints and other related matters. Thank you. May I then hand over to the acting DG or the Honorable Deputy Minister first, and then he will then decide on how he allocates the responsibilities.
Thank you, Chairperson, Honorable Chairperson. Let me greet the honorable members, colleagues, and I heard you, Chairperson, saying the acting DG is here and she is welcomed. So I just realized that there is information that has not reached you probably. The acting DG is a he, is no longer a she. Mr.
Wow.
Heyman, yes, I think he's part of, he's on the platform also. Are you there, Mr. Heyman?
I am, DM, thank you.
Yes.
Oh,
So,
my apologies. But it's not a train smash. This is a new South Africa. Thank you too.
Okay, Chairperson. Can I therefore right away request the honorable?
Yes, please.
I mean the acting DG to deploy accordingly and give us the presentation.
Thank you, DM. I'm on the floor. I will put my camera on so that the Portfolio Committee can see me. There we go. Good morning to the Portfolio Committee, honorable members. Person, I just want to thank you for the opportunity this morning to present to you on this matter. I just want to acknowledge also the presence of the Deputy Minister. And we are grateful for his leadership and guidance on all these matters. He's stood with us the whole week. Apologies. I also want to recognize Mr. Ndove, the Deputy Director General for Land Redistribution and Tenure Reform, Mr. Manda Lekoto, the Acting Registrar of Communal Property Associations in the department, and two officials who will lead today's briefings, Chairperson. The one is Mr. Richard Kiotile, who is the Chief Director, Provincial Shared Services Centre in the Northwest, and the other is Advocate Kenneth Matukane, who is the Acting Regional Land Claims Commissioner for the same province. I further acknowledge that the officials of the Department of Land Reform and I further acknowledge the other officials from the Department of Land Reform and Rural Development who are in attendance today for support to the session. Chairperson, we appear before the committee this morning to deal with two complaints that were formally submitted to Parliament by members of the public. These matters were referred to the Department for attention, and coordination of the appropriate response is then tabled here today. Both related concerns were raised by property associations in the Northwest Province, and both deal with governance, historical disposition, and the management of land rights under the current frameworks that we have. The first matter concerns the Ramotlakane Community Property Association, where complaint has been raised by Ms. Slugwani. The issues raised relate to the administration of CPA assets, questions about the validity of household lists, internal governance practices, and transparency of financial and lease-related decisions. The matters are familiar to the department, and following elections that the department facilitated in September 2023, we have remained engaged with this community and the elected committee. In response to ongoing concerns, the department has initiated, obviously, a formal verification process, appointed a researcher to support that process, and scheduled compliance support measures for the implementation in the financial year, which you will clearly see are presented by Mr. Kiotile in the upcoming presentation. Further technical detail on the scope and the complaint are then to be provided in this session. The second matter of concern is a complaint lodged by Mr. David Rampe in relation to the Bakwena Modimosana CPA. The complaint spans several concerns, including allegations regarding unprocessed land claims, disputes over recognition with traditional leaders and structures, and the dissatisfaction with low land and dissatisfaction on how land in and around the Pilanesberg area has been allocated and restored. Some aspects relate to the restitution framework, while others fall within mandates of other institutions, such as the Department of Minerals, Resources and Energy and the Department of Cooperative Governance. But again, the advocate will point out all of these in the detailed presentation. The department has ensured that the matters falling within its legal responsibilities have been directed to the Office of the Regional Land Claims Commissioner, who will then outline these in the presentation. I think what's obvious and from both complaints is that the issues raised here go beyond administration. They involve contested histories, unresolved questions about recognition and representation, and require coordination between multiple public institutions. And Chair, each complaint touches on matters that remain sensitive at community level and institutionally complex for the state. We welcome the committee's oversight and the opportunity to present these formally today. I now would like to invite Mr. The Chief Director in the Provincial Shared Service Centre, Mr. Richard Kiotile, to present on the Ramotlakane CPA complaint, and followed by that, and obviously given your guidance, Chair, we will take Advocate Matekane will brief the committee on the Bakwena Modimosana matter. Thank you, Chair.
Thank you. Thank you, Honorable Acting Acting DG. Well, it's over to your team.
Yeah. Good morning, Honorable Chair, Honorable Members, Deputy Minister, the Executive Management of the Department, and colleagues in attendance. I'm not sure if I'm audible or visible. I've tried to unmute. I'm sure
you are audible, Mr. Kiotile. It's just the presentation is not showing.
Okay, I will request Mr. Ralph or Melissa to share the presentation, and then I will run through the presentation. Thanks. As the Acting Director General has indicated.
Excuse me, sir, can I ask you to actually open the video? Because for streaming, they would need to see your face.
I have,
Hello?
Honorable. Yes,
Oh.
I have. I have on my side. Maybe it's the quality of network that is not enabling the video to show. But on my side, I have made both the video and the audio on.
Sorry, Chair. Mr. Gutalo, can you check if your camera is open? Sometimes it's closed there if you're using the laptop and it's not able to show. Thanks.
No, it's on. Oh, thanks, DM. Yes, good morning, Chair, honorable members. I'm sure now I'm visible.
Yes,
My
we
name
can
is.
see you now. We can see you now.
Thanks. My name is Richard Taylor, Chief Director for Northwest Province, responsible for the department in the province. I will be presenting on behalf of the department for complaints lodged by Mayor Hlungwane in relation to Ramotlakane CPA. If the presentation can be made in a slide mode. Thanks. Yes.
The presentation is on a slide mode from my side.
Yeah, thanks. Yeah, I can see. Like the acting DG has introduced the subject, the purpose here is to provide the committee with a brief report about the status of Ramotlakane Communal Property Association, and also to provide responses, interventions, and a time-bound plan to address complaints submitted by Hlungwane regarding the allegation of maladministration at the CPA. We can go to the next slide. That's the purpose. And then the next slide, we will dwell into the background information about this CPA. This CPA obviously was established as a result of successful land claim. And then there is a registration of this CPA to qualify that it is a legit CPA that we all know about. It has got members. It has got the constitution, of course, which is in line with the CPA Act. The officials in this CPA, we have about 10, which includes the chairperson, deputy chair, secretary, the officials in totality, together with additional members who are elected by beneficiaries of this particular CPA. And then when we continue with the background, we indicate that the department appointed an election agency to facilitate the elections of this particular CPA in 2023 for a period of 5 years. Their term of office is 5 years, and of course, that term of office is ending in 2028. And the complainant in this regard, which is Mayor Hlungwane, is also a member of this executive, holding the position of a secretary in the committee. This particular CPA lodged claims on about 2 farms, Lipan and Lilyfontein. So to date, 4,652 hectares has been restored. and of course, the verified members of this CPA is about 743 households. That's the verified households that are benefiting from this particular CPA. Next slide, please. And on 1st April 2025, I will just limit the complaints to what we have on record, of course, submitted to the portfolio committee and ourselves. Mayor Hlungwane wrote to honorable members of the portfolio committee about the following 9 allegations. I will mention all of them, 9 of them. The first one, portion 0 does not appear among their portions. In 2010, Meiki Matla provided us with a report indicating that portion 21, amongst other portions, was supposed to be transferred to Ramotlakane, but it still hasn't been transferred as part of phase 2 portions bought for the CPA. Number C, the treasurer has failed to present the audited financial reports from 2018 to present. Number D, the Baki should be returned to Ms. Tamusetle as it was previously stored there before the chairperson and treasurer decided to use it for personal purposes. Number E, the 3 laptops which were never handed over were claimed to be broken. Number F, the 2 members elected by the verification, business and disciplinary committees, along with some EXCO members, were chosen in a way that violates the CPA constitution. Number G is misuse of funds. H, the chairperson has refused to share all lease contracts which generate income with the EXCO. And the last one, which is I, lack of transparency from the treasurer and chairperson regarding the funds. I will go straight to the responses. The first response, obviously the questions or the challenges were leveled against the executive committee, and of course the department also had to intervene on numerous occasions. So as we respond, we will indicate both the intervention by the department and the CPA committee. To the first 2 questions, which is portion 0 matter and the 2010 matter, the response is that all the land owners of these portions still outstanding to be restored, which is portion 0 and portion 21. The landowners have rejected the outcome of the research. They refused that the land should be restored. They were citing that, of course, they don't accept the outcomes of the research. They are disputing the merits of the claim. So now, where we stand as a department, the department is of the view that a further research is necessary so that by the time we start taking the claim to the land court, we should have more facts to can really challenge what the landowners of the 2 farms, of the portions in the 2 farms, which is Lilifontein and Klippan. These 2 farms are about 13,000 hectares combined within the borders of the 2 districts, which is Bujanala and Dr. KK. So portions that have been restored amount to 4,600, and then the remainder of 13,000 and 4,600 has not been restored because the owners are disputing the validity of the claim. And of course, on records, we agree that they have not been restored, and the department is committing, is doing further research so that we can have enough facts to can really take them to court towards working towards finalizing the land claim in question. At a certain point, indeed, portion 21 was gazetted. There was an approval with section 42D approved by the minister, but of course, if it's not up, the owner doesn't accept and accept the research, there was nothing we could do further. The next question, which is number C, the treasurer has failed to present the audited financial reports from 2018 to present. The committee indicated that they have been conducting audits and presenting reports to the general members. The department has requested financial statements, but were only furnished with financial reports with no audited financial statement. We accept that, yes, there are no audited financial statement, but the reports have been forthcoming because anyway, the CPA, it's a legal persona. Of course, as a department, we get reports regularly. We confirm the reports, but not audited financial statement. Number D is the Baki should be returned. The reports we got from the CPA, the treasurer indicated the Baki is in his possession and is not functioning as a result, and currently is in a state of disrepair. When needed, the Baki could be availed for alternative safekeeping. Number E, which was the next question, which was the next complaint, which was raised. 3 laptops which were never handed over were claimed to be broken. Yes, the members accepted that, yes, those laptops were bought from second-hand shop, which is Cash Crusaders. And then obviously after a period of time, they lost value. The committee never pursued those laptops because they didn't consider them to be tangible assets that could be handed over from one committee to the other. So when we engaged with the committee, these are the explanations they've provided us. And of course, One is aware of these responses from the committee regarding the laptops. The next complaint was F. Was numbered F. The 2 members elected by the Verification, Business and Disciplinary Committee. Yes, the committee indicated they have removed 2 members, which is the PRO and additional member. They were found to be members not in good standing. The department has since committed to follow up and establish if indeed the CPA process was violated in changing their membership. The verification of members or claimants seems to be the same source of the problems in the CPA. So this relates to all the challenges that are there, where some members are disputing others to be members, because this CPA has got members from different towns because of land dispossessions. The current beneficiary are in Rustenburg, in Bretts, in Mafeking, in Johannesburg, Carltonville, and some even as far as in Mpumalanga. So we will continue to try to address this verification. The RLCC has appointed a researcher to conduct research that will also address the issue of members who are qualifying to be dispossessed households. So it's an ongoing process of trying to establish the real beneficiaries, because we are in, if not the third, is the 4th generations, because dispossession happened decades ago. The elders used to stay together. Now we are working with the children of the dispossessed. That is why you will have all these challenges where others are disputing the others to be beneficiaries. These are the challenges that we are facing as a result of land dispossession. Misuse of funds, or the issue of misuse of funds, the issues was raised several times with the committee, indicating that the committee indicated their annual income is only around 1.3 million per annum. It's only 4,600 hectares that they are using to generate this much. And most of the money is used to fund their general meetings, which cost not less than 100,000. And they spend most of their money on transport and catering. And for one meeting, which is annual general meeting that they have almost annually, they will spend around this amount of money transporting beneficiaries from all over, mainly two provinces, which is Northwest and Gauteng, and it doesn't make much. And they even have 7 employees who are permanently employed by the CPA, and the department is encouraging them to do audits of their finances regularly so that they can account annually to the members. So we can only encourage, because the CPA, by its nature, it's a legal persona. We advise, we support, we motivate, we shape them, but they do the actual work. They transact as a CPA. Yeah. The next one was complaint regarding the chairperson has refused to share lease contracts, which generates revenue and lack of transparency. The committee has indicated that they got into office, the lease was around 400 per hectare, and then they consulted with NWK Norvesco Prasi based on their advice. They have recently upped the rental for the leases to around 1,500 per hectare, which means the prospects will be good going forward. They will generate more money because now they will charge more going forward. And they have further indicated that there are almost 15 members of the CPA who have a lease but are not paying. Those members include the chairperson, the treasurer, as well as Ms. Mapule Tlungwani herself, who has recently terminated her lease. So it's just administrative challenges within the CPA, and of course a small piece of land that they have. Members will appreciate that for households of around 700, sharing 4,600 hectares, really the returns shouldn't be that much. They cannot be that much unless if it's comprehensive agricultural production. So it's just grains production. That's why they couldn't make much. The department has also noted that there are policy guidelines in terms of allocating or leasing land to the CPA members, and this has created some internal conflicts. The department will further request the CPA to provide all information regarding lease contracts. However, when engaging the chairperson on this matter, he indicated that this is not true. With regard to the chairperson refusing to share the lease, he further engagement will be undertaken with the committee to establish facts with regard to the committee to prepare a full report on this allegation, because according to the chairperson, the information is readily available. So going forward, we felt we need to give the complaint more attention and really have a plan with time bounds that will make sure that the portfolio committee, through the oversight mandate, they are able to track the performance and towards the closure of the challenges as identified. So the first activity, we will arrange a meeting of the committee and the concerned members, the purpose there being to identify issues that needs to be resolved jointly, and that need intervention of the department and Land Claims Commission. So the stakeholders there will be the CPA committee, the concerned members, the department, and the Land Restitution Commission. And we have put ourselves at timelines of about the 30th of August. This should happen before the 30th of August. The second activity will be to assess an assessment of the issues complaint raised at the meeting. So the very same meeting that will happen by the 30th of August, obviously we'll be doing the activity number 2, which is assessment of those issues. The purpose thereof obviously will be to determine if there is a need to appoint an independent mediator or resolve the issues internally. And then that will be us as a department together with restitution. That determination we will make by the 20th of September. That is the final date. It can happen before then. And then the last one, the third one, will be to arrange a general meeting to brief the general members about the complaints raised by concerned members and present the activity plan. That will be the general CPA members who will be transported from all over to come to the farm so that we have that general meeting with members. And then the CPA committee will be there, concerned members will be there, the department and restitution commission will be there. Such a meeting will happen on the 30th, before the 30th of September, so that we address all issues jointly with all stakeholders being present, all allegations, everything, and we will be in a position to really help them to fix all issues that are identified as challenges. The fourth one will be training on governance and compliance. The purpose being to ensure that the committee and some members of the CPA are capacitated. We all are aware of the challenges brought by land dispossessions. People are scattered all over, struggling for economic opportunities. So when we give them land after land restoration, capacities lacking here and there. So continuously we must also embark on a program to capacitate the CPA members, including the committee, so that there can be unity and cohesion when attending to various issues relating to their land as they receive land from a successful land claim process. And then finally, on the last slide, the department has observed that there are some weaknesses about the decision-making process. The CPA needs to be capacitated about decision-making procedures, policy development and implementation of governance skills that enable them to properly manage the affairs of the CPA. The department is committing to provide support by calling a general meeting to address some of the main complaints leveled against the CPA committee members. The department will also enhance training of the CPA committee on compliance and governance by end of September, so that all these challenges could be eliminated, although it might be difficult to eliminate personal differences, but these are the interventions that we will embark upon as a department, so that we've got smooth running and eventually this CPA can be compliant like other CPAs that we have. I think now the last slide should be a thank you slide from our side. Thank you, Chairperson.
Thank you. Thank you for this lucid, presentation on the two. I was actually going to ask you to continue with the other CPAs, another issue, the Rampe Royal family issue, so that when we begin to discuss these, we discuss all of them at once.
Thank you, Chair. Advocate Matukane will now do the second presentation. Thank you, Advocate.
Thank you, DG, Acting DG. Thank you, Deputy Minister, Chairperson, the executive members of the Portfolio Committee, and the executive members of the department. My name is Kenneth Matukani. I'm the Acting Chief Director in the Office of the Regional Land Claims Commissioner in the Northwest Province. I will request Mr. Ralph to fly to the presentation on Rambe, or Ms. Melissa Chetty, so that I can take the honorable members of the Portfolio Committee through the presentation. Thank you.
It is being loaded. Thank you.
In terms of the video, you're able to see me?
It's there.
Okay, if we can put it on a slide mode. I'm not sure, Chairperson, if in terms of the video you are able to see me on your side, because of it is on my side.
Matukani, we can't see you right now. You were visible earlier. There you are now. Thank you.
Okay.
You can proceed, please. Thanks.
All right. Wonderful. Yeah. Members, this is the briefing to the Portfolio Committee on Land Reform and Rural Development on the complaint lodged by Mr. Rampe of Bakwena Modimosana CPA. It is situated in Bojanala district in the Northwest Province. If we can move to the next slide, please. Yeah, basically we are dealing with two issues. And the reason why we have put the first item being the mandate of the commission, the land restitution process, and who qualifies in terms of our qualification criteria as dictated for by the Restitution Act, is because of the nature of the issues which were raised by the complainant. And therefore, we felt that it is important to reiterate what the mandate of the commission really is, and the restitution process from beginning to end, and the qualification criteria. But the second point is really to deal with the complaint itself and the steps that we've taken as the commission to address the complaint. I need to indicate that this is not the first time we're addressing this complaint. I think this is the third, if not the fourth time, that we have addressed similar issues in the past. And so we can move to the next slide. The next slide. Yeah, basically, Chair, here it is just to just put in context, because of that's what the complaint seeks to raise. And then we spoke about the mandate really of the commission, to say that it is found, of course, as the honorable members would know, in terms of section 25(7) of the Constitution of the Republic, that we only deal with people. It's either it's a person or a community dispossessed of property after 19 June 1913 as a result of past racially discriminatory laws and or practices. And this person is entitled, of course, to the extent provided by an Act of Parliament, either to restitution of that property or to equitable redress. Therefore, in terms of the 1994 processes, Parliament enacted the Restitution of Land Rights Act 22 of 1994 to give effect and operationalize the fundamental right that is provided for in section 25(7) of the Constitution. Now, the Restitution Act itself establishes the commission to investigate and settle claims, and we do this through a normal administrative process. But the Land Court is established by the Land Court, and this, amongst others, is to deal with matters which cannot be finalized administratively by the commission. This might include, one, where the landowners, as Mr. Gotaile has pointed out, that some of the properties that are outstanding to be finalized with the Ramotlakane CPA is because of, upon the publication in the Government Gazette notice, I think it was in 2005, the affected landowners disputed the merits of the case. And therefore, such cases get to be referred in terms of Section 14 of the Restitution Act. But you find instances where the landowners accept the merits, we conduct valuation, and they do not accept the price. Then we refer it in terms of Section 42E, which provides for the expropriation of the land, of course, with compensation. And therefore, the mandate of the Commission, Chairperson, it's really a simple one, is to receive, investigate, and settle land restitution claims. The second slide. Basically here, we always take the complainant through the restitution process because there seem to be a misunderstanding in terms of the business process from the complainant, that it is a simple one. It starts with the lodgement of the claim. We conduct investigation in terms of Section 10 and 2 of the Restitution Act. Here, basically, we want to establish if the claim meets the requirements of the Act or if it doesn't. If it does, it goes to the next process, which we refer to it as validation. It means we are satisfied that the claim meets the requirements of the Act, and therefore we will proceed to publish it in the Government Gazette, calling upon all the interested parties to comment whether or not they accept the claim. This also involves the affected landowners and any other party who is affected by the claim. Should it fall short of the requirements of the Act, then we will find it to be non-compliant. In the Commission, we use the term non-compliant, but normally I know it is interchangeably used with the term dismissal. Therefore, but the proper weight is that we find it to be non-compliant with the Restitution Act. If it's indeed compliant, it moves to negotiations. Negotiations involves conducting a valuation on the property to determine the value thereof and giving an offer to the landowner. If, of course, the landowner accepts, if it is land restoration or if it is a financial compensation award, the claimant accepts the restitution award, it will move to settlement, where we require either the Chief Land Claims Commissioner, if such settlement is below 50 million, or the Minister, if the settlement is above 50 million, to approve the settlement. Then we would consider the claim settled. Then the finalization, therefore, it would actually involve the transfer of the actual hectares that have been settled by the Minister or the Land Claims or the Chief Land Claims Commissioner, or the payment of financial compensation.
How is life?
In case.
Okay. No problem.
Okay, Chairperson, I'm not sure if I think
I know, but I developed the way of managing different responsibilities.
Chair, I'm not sure that
there is an interference. Can we actually, mute ourselves while the presentations are actually being made, because there is an interference from the noises in the background.
Okay. Apologies, Chair.
Okay, no thanks, Chair. Then we can move to the next slide. Yeah, basically here we wanted to reiterate who is entitled in terms of Section 2 of the Restitution Act. The qualification is quite straightforward, Chair, is that a person shall be entitled to restitution of a right in land, one, if is a person or a community dispossessed of such a right, and the dispossession should have happened prior or on the 19th of June 1913, the dispossession should have been as a result of a racially discriminatory law and or practice, and the claimant should have lodged a claim no later than the 31st of December 1998. And the most important one is that no just and equitable redress should have been paid at the time of dispossession. And so if you meet these requirements, then we would say that your claim is compliant in terms of the Restitution Act. But if one of them falls short, then we would refer it as a claim that is non-compliant. The next slide. Yeah, now we will go to the actual summary of the complaint by Mr. Rampe or the Rampe Royal household. Basically, the complaint evolves around 4 issues. The first one is that Mr. Rampe complained that they have lodged a claim on the farms Makokstad, Shylock, Kraaihoek. Kraaihoek is where there's a game lodge called Molokwane, just on the N4. It's about 15 kilometers outside of Rustenburg towards Swartregens. And this claim also is inclusive of their royal burial sites. And they're saying that these claims were lodged between the first window period, meaning before the 31st of December 1998. The second complaint is about the internal conflicts that are happening between the Rampe Royal family and the current chief Lekwabe of Bakwena Modimosana Bamaka. And the third one is that they have lodged a land restitution claim on the farm Bukenode, and this farm was given to Bafokeng community by the then government. And the Glencoe Mining Company is currently mining there, with all the benefits accruing to Bafokeng and not them as a community. The fourth one is that they are entitled to properties lodged within the Pilanesberg Nature Reserve in Northwest in the Bojanala district. And these properties we have since as a commission restored to Bakafela community that are in Morogwen. It's about 40 km towards the north of the town of Rustenburg. Now we will deal with how we have addressed the complaint. In our response, Chair, regarding the alleged lodged claims on the farms Makokskral, 256, Shylock, and Kraaihoek, we've commissioned an investigations internally, and we discovered that there were no land claims lodged by the Rampe family or the Rampe Royal household on these farms, namely Makokskral, Shylock, and Kraaihoek, under the old order period for the lodgement of claims. As I have indicated, the period was before the 31st of December 1998. However, we have since discovered that yes, indeed, there were claims that were lodged between the new window period of 2014 and 2016. The claim was lodged by Mr. Rampe, and it was lodged on the farms Shylock 256 JQ, Makgathashoek 270 JQ, Folkwell 324 JQ, Mooihoek 291 JQ, Union 252 JQ, Kraaihoek 269 JQ, and Kraaihoek 592 JQ, Avondale 315 JQ, and Avondstond 295 JQ. These claims were lodged, but they were not lodged during the first window period. They were lodged when the new claims were reopened for the lodgement of new ones. And it is a well-known fact, Chair, that with the new order claims lodged between 2014 and 2016, the processing of claims lodged during this period were interdicted by the Constitutional Court in the Lamosa judgment. Lamosa is the Land Access Movement of South Africa, which took the department to court and said, we want to prevent the department to process the new order claims. Part of the judgment by the Constitutional Court, it found out that Parliament, when it enacted the amendment bill for the reopening of claims, it did not consult adequately. It's some of the reasons that were raised by the Constitutional Court. And again, the Commission was required to deal with the new order claims. Now, the process required that until Parliament enacts the new law, after it had followed all processes, including proper consultations and other legislative requirements, then it's only then once Parliament passes the new law that we can be able to deal with the new order claims. But as of now, we are restricted. But what the Constitutional Court declared is that those claims are nevertheless validly lodged. It's just that the Commission is restricted to deal with them at this current moment until advised otherwise. We can move to the next slide. The next slide it's complaint number 2, which deals with internal conflicts between the Rampe Royal family and the current Chief Lekwabe of Bakwena Modimosana. This is not the first time, Chair, this complaint is being raised. Around that community, Bakwena Modimosana, history tells us that there were about 4 Bakwena Modimosana communities. Is Bakwena Maka, is Bakwena Matlaku, is Bakwena Modimosana, and is Bakwena Matau. Rampe Royal household has always contended that they were the 5th royal family. But upon consultation, there's a rich history around Bakwena Modimosana. In actual fact, where they were removed, it has been declared a Category 1 heritage site. More than 25,000 people, if you go to their history, there's actually books that were written on them, how they were dispossessed and how they were removed and scattered. Basically, they were one big community, but the 4 sons, they separated, and these 4 communities, they basically actually are related. It's 4 sons called Maka, Matlaku, Modimosana, and Matau. They had separated. And they always contended that there was never any other royal household that was dispossessed around that area. But the Rampe family has always raised this issue that they are part of the 5, which makes them the 5th royal household that was affected by the dispossession. But we have seen that since this thing has escalated into a conflict between not only with Maka, but with also Modimosana, Matlaku, and Matau, we have advised them they should consult with the Department of Cooperative Governance and Traditional Affairs, because of, as the Commission, our mandate really is restricted to receiving investigation and settlement of land claims, and therefore we're not going to be able to be in a position to assist them on the issues of chieftaincy and related matters. And therefore we have gotten them in contact with the Department of COPTA. We can move to the 3rd complaint. This complaint is relating to the farm book and hold, and Mr. Rampe and the royal family are alleging that it has been given to Bafokeng through arrangements with the then, they refer it as the apartheid government, and that the Glencore Mining Company is currently mining there, and all the benefits are actually accruing to Bafokeng. In terms of our investigation, we found that for one, because of anything that connects the Commission to a complaint or a process, it's a land claim. the fundamental question is there a land claim on the property that we are dealing with? And we found out, firstly, that there is no land claim on the farm book and note lodged by the Rampe family or the Rampe Royal household. It is not there during the old order period for the lodgement of claims. And again, in this instance, the Rampe family was advised that despite the issues of the alleged land claim on this farm, the family needs to approach the Department of Mineral Resources on the issues of mining operations on the farm. They might perhaps have other rights that they possibly might have that are not necessarily land reform related, but then perhaps they might be advised appropriately by this department in terms of their possible action going forward. And we said that through this engagement, they might actually be assisted on the relations that Royal Bafokeng, as the beneficiaries in that mining operation, are having with the Glencore Mining Company. And therefore, we are unable to take the matter further than the advice that we have given them. The fourth complaint. Next slide. Yeah, this complaint relates again to entitlement because of their saying that they are entitled to the properties that have been lodged within the Pilanesberg Nature Reserve. Pilanesberg Nature Reserve, Chair, it's where the Sun City and all other lodges that, you know, high-end lodges are located. They are all in Pilanesberg Nature Reserve. And so the Rampe family says, we have wrongfully restored those properties to Bakatla Bakafel as a community. Just as a background, we received a land claim within Pilanesberg Game Nature Reserve, Chair. The claim was lodged before the deadline of the 31st of December 1998. We received it from Bakatla Bakafel. The claim was investigated and it was found to be compliant with Section 2 of the Restitution Act. Just a quick background on Pilanesberg. It is a reserve with about 57,200 hectares in extent. And as an office, we have restored more than 26,000 hectares to Bakatla Bakafela within Pilanesberg. And we are in the process of restoring the outstanding 11,994 hectares. The land that has already been restored, if you... Yeah.
Excuse me, can I please actually appeal to honorable members to keep their phones or whatever they are using, their gadgets muted so that we do not actually get disturbed by noises that come in the background. Please.
Okay, thank you, Chair.
You may continue.
Yeah. The land that has already been restored, meaning the 26,000 hectares, it basically constitutes 45% of the land within Pilanesberg. But we're saying once we have restored the entire 38,000 hectares, the communities within Pilanesberg, because of it's not only Bakatla Bakafela within Pilanesberg, you've got the Velgefal community, you've got Bapolomiti, and you've got RKM families. All the land, Chair, will constitute more than 66% of the land within Pilanesberg. And so we are proud to say that we are changing the land patterns. And so the ownership of Pilanesberg currently, 2/3 of it will be in the hands of these communities. We have actually said to the royal family, as it is called, that when we published these 4 claims, after we have researched them and we found them to be compliant, we never received any objections, because normally we publish it in the Government Gazette, calling upon all the interested parties to make representations, and we never received any objections, including from the Rambe Royal household. And therefore, that's why we proceeded to settle all the 4 claims, including the claim of Bakatla. We have advised the Rambe family that since they have an option to approach the land claims, the land court, if they wish to challenge the settlement of the claim. Because in terms of the Act, the Regional Land Claims Commissioner cannot review his own administrative decision on the matter. And so they've been advised that maybe perhaps, we've already restored 26,000 hectares within Pilanesberg. And therefore, if they should challenge this settlement, the appropriate, I think, route to take is to approach the court with a view to review the decision of the Regional Land Claims Commissioner. Yeah, that's the end of the presentation, Chair. I will pause there and thank you to the members.
Well, thank you so much to the Commission. In respect of the Ramotlakane matter, I did not hear the Commission actually saying anything about the outstanding portions of the Ramotlakane claims. Given that you actually, in your report, indicated that you actually are dealing with that claim in phases. Now, I did not hear what the status is in respect of the outstanding portions of their claim. I wonder if you can actually zoom into that right away before members actually discuss your presentation.
No, thank you, Chair, for affording that opportunity. Maybe I will ask Ms. Chetty or Mr. Ralph to actually flight the report from the Commission because of it actually summarizes the status of the claim on Ramotlakane as far as the Commission is concerned. Ms. Chetty? But in the absence of that, I can quickly talk to it, Chair. But it would be wise just to have it on the platform for us so that I can talk to it. Ms. Chetty?
Ralph is loading. Thank you.
Okay.
Advocate, I think you can start talking while we get the report up. The report, okay, Chairperson, has been circulated also as part of the pack, I believe. Thank you.
No, thanks, Acting DG. A quick update on the report, Chair, is that this is a claim by Ramotlakane. The claim was lodged by Mr. Pitizeni Jeremiah Makaula. The claim was lodged on the 30th of December 1998. The claimant lodged in his capacity as one of the descendants of the original dispossessed individuals. The claimants occupied the properties since the 1800s in terms of the research report that was conducted. And the dispossession actually occurred around 1947. We investigated the claim and it was found to be compliant with the Restitution Act, and it was published in the Government Gazette Notice of 672 in 2005. Yeah, there we are. If Ralph, you can assist me to go to 1.3. 1.3. If we can just go down. Yes, that's where we are. We conducted verification of all the direct descendants of the original dispossessed individuals on the 30th of September 2005, and a total number of fully verified households and beneficiaries is as follows. In phase 1, we verified 377 households, which constituted 671 beneficiaries. In phase 2, there was no verification that was conducted, but in phase 3, additional 386 households constituting 743 households were verified. If I can just quickly explain what we mean by phases, Chair. When we investigate a claim and there are multiple landowners affected and we publish it in the Government Gazette, not all landowners agree to the merits of the case. And therefore, you would find out of 10 landowners, 2 come forth and says, we are happy with your findings. We are prepared to sell. We do valuations, and if they accept the offers, we do not want to wait for the entire 10 to agree. We will say, let us do phase 1 of the settlement of the claim. Therefore, those landowners, we would say they constitute phase 1 with those properties. But as we do that, we verify, we say in that verification, how many households were we able to verify? Hence, you see that under phase 1, we verified 377. But when we did phase 3, we verified an additional 743. Now, let us go quickly to the summary of the claim, Ralph. Yeah, if you can, if you can stop there. As you can see, Chair, the total hectares that were claimed and accepted in terms of the Act, it was 11,490 hectares. To date, we have restored 4,652. Total hectares that are outstanding to be restored, it's 6,837. The portions that we've restored, there are about 14. They appear on that column. The hectares that are outstanding to be restored, it's about 21. And then where the landowners are actually disputing the merits of the case. And when we conducted the initial research report, we discovered that there were a lot of loopholes in terms of tightening all the loose ends to make sure that when we go to the court, we've got a tight case that we can defend. But when we looked at the research report, we discovered that maybe the best thing is to conduct further research so that when we refer the matter to court in terms of Section 14, we are able, the claim can stand the test that is going to put through, because of even the owners of these properties, they appoint highly skilled researchers to do their own research to dispute the findings of the commission. So that is where we are currently. If we can move to 1.5. Yeah, we're saying we wanted to clarify this one because it's one of the contentious issues that Mr. Kotaile presented in the report, in his report, but it was mostly relating to the issues of governance. But in as far as the restitution process is concerned, is that with regards to portion 7, 13, 17, and 21 of the Farm Club Ban, there was an approved, and I'm saying this because of part of the allegations or the complaint, let's rather call it a complaint by Mr. Hlungwane, is that portion 21 in 2010, it was promised by Mr. Meiki Matlala that it will be restored to them. That statement was actually correct at the time. There was an approved Section 42D and portion 21 was part of that approval. And the settlement agreement the settlement agreement was approved by the minister in terms of the 42D. However, after that approval, the affected landowners refused to sign the sale agreement, citing that it took long for the minister to approve and the acquisition of farms and the prices thereof has since gone up. And so the office unfortunately was unable to proceed with the acquisition of those farms. But now that amount, because of it was already approved, it remained in the commitment as a commitment in the books of the commission. And therefore, we had to do a declaration memo so that the amount and the properties that were restored, including portion 21, had to be declared. That is why when you look at the column where I've presented the outstanding portions, portion 21, it's also there. Now, part of another complaint by the claimant is that portion 0, which is the remaining extent, does not appear among the portions that have been claimed, and further that portion 21 was supposed to have been transferred to them, and it still has not been transferred to them. If you look at the column of outstanding portions, both portion 0 and portion 21 are still outstanding to be settled. Portion 21 has never been settled at all because of the owner is contending the merits of the case. Portion 21, as I said, it was approved, but subsequent to that approval, the landowner refused to sign the sale agreement and it had to be declared. And so it's part of the properties that are still outstanding to be settled. That is why I wanted to make it clear on our side. These are just the portions that were declared. I'm not going to go through it because I've actually explained this table. Actually, the relevant portion is portion 21 that we could not proceed to settle. 1.8, as we have said, Chair, all the landowners of the portion still outstanding to be restored. There you have it, the remaining extent, which is portion 0, and all other portions, including portion 21, have disputed the merits of the case, and the office has taken a decision to commission further research on the claim. And since the research report commissioned in 2005 was not clear in terms of the qualification of the claim, and we felt that we cannot take such a report to the land court because of we will be failing the claimants in our duty as the commission. 1.9. Yeah, these are other reasons. Maybe we can go to, other reasons for commissioning of further research. The biggest dispute, Chair, here is that the claimants are unable to produce a proper originally dispossessed individual list. The first submitted ODI list was 83 households and the second one was 58 households. There are disputes between the claimants. Some are disputing the number of the ODIs on the list and others are disputing who the rightful beneficiaries should be. Some claimants are alleging that others are not rightful beneficiaries, but they are on the submitted ODI list. On the 20th of June 2023, the CPA Executive Committee wrote a letter to the office requesting further research and the verification of the entire claim. 2.2, the office was approached by several families that alleged that they are not satisfied with the recent ODI list given to the office by the CPA Executive Committee because of the number of people on the ODI list. The families query that the number of people who were dispossessed were not more than 20 families. They further indicated that further research will assist the office with finding a conclusion to this matter. The next paragraph. And therefore, the current status of the claim is that we have appointed, the department firstly appointed an election agency to facilitate the elections, and a new committee was elected on the 16th of September 2023. Mr. Gotele has alluded to that. But immediately after the elections, the office received an email alleging that some of the elected committee members were not the rightful beneficiaries. The office, therefore, is intending to intervene and conduct a proper verification. But some members within the executive committee are not happy with the process of re-verification. 3.3. Yeah, and then the other one is that the owners are disputing the merits, and therefore we have to do a further research. We have resolved, Chair, that the only way to resolve the dispute between the CPA Executive Committee and the families concerned is by conducting further research. Part of the research, we want homestead identification. Who were the original dispossessed individuals who were dispossessed on the farm? Because of how we do verification as the commission is, we would appoint a committee of elders chosen by the claimants themselves. These are people who are able to give us guidance on who the original dispossessed individuals were. And from that list, they will assist us to compile the verification of households that are descending from those original dispossessed individuals. But with verification, the challenge is that we are dealing with the third and the fourth generation. Now, if the original dispossessed individuals who experienced the first-hand dispossession are not there, and you've got children, some were born there, they know each other, but the majority of them were not even born on the farm. They were born after they were dispossessed. The only people who know the history are the ODIs, the original dispossessed individuals. And therefore, it becomes very, very difficult for them to verify each other. It's accusation and counter-accusation and say, if you say I am not the rightful beneficiary, how do you know? Because of you yourself, you were never staying there. You got that information somewhere. And so, unfortunately, we are confronted, Chair, with those kind of challenges. And so we said, though the Committee of Elders, to some extent, they help, but we think the homestead identification, it will actually resolve the issue because of that homestead identification will talk to the original dispossessed individuals. Because of some of the allegations is that you guys have already verified 753 households. There were actually only 20 households that were removed from these farms. So we hope that the research will actually put this issue of who is the rightful beneficiary, who is not, to bed, Chair. So basically that is the long and the short part of the Ramotlakane CPA in as far as their restitution claim is concerned. Thank you, Chair.
Well, thank you very much to the Commission. Honorable members, it's your turn now to make, your inputs, to question, and also make comments. I would like to recognize hands and ask the Secretariat to also help me in the identification of the hands. Already I can see there are 3 hands up. One from Honorable Kutama, Honorable Mtetwa, Honorable Adams,
Honorable Ndalane.
Honorable Ndalane.
The iPad is Matigize.
Honorable iPad. I know I'm going to actually get
Honorable Mkhacha, Chair.
I was about to say that I'm expecting a hand from Honorable Mkhacha. I was going to write him anyway because I knew he was going to come up. Who else's hand is up and has not been actually recognized? Okay, let's start going. Honorable Kutama.
Thank you, Chair, and the honorable members.
May I make an appeal once again to those who have not actually. Oh, please. Honorable members, can we actually mute our gadgets? I don't know what's going on here. Can we mute our gadgets? Honorable Kitama, sorry about this. You are on the floor. Honorable Kitama.
Okay, thank you, Chair. Chair, I just want to say that we are not going to be able to deal with the problems of the CPAs in this manner. There are too many, too complex. So we are not going to be able to take laptops taken there, documents disappearing and all that. So the solution is to establish that office of the Communal Property Association, which will be able to deal with all these complex matters. And so I'm just wondering, how soon can that office be established? Otherwise, every week we're going to be dealing with complaints from communal property associations crises. And I don't think this committee is able to deal with that. Somebody's interjection there. But that is the extent of my contribution, that we're not going to be able to deal with all these matters in this manner. We need that office to be established so that it takes care of the details. We will get proper reports from that office about how the crises are being handled. Thank you.
Well, thank you, Honorable Kutama. Can we actually then move on to Honorable Mteto?
Greetings, Chair, and greetings to the Deputy Minister and the Minister in absentia and the acting DG and fellow officials and fellow portfolio committee members. May I give my observation? Mr. Matukane, I heard one side of him advising the Rampe Royal House on the steps that they must take upon realizing that there are certain verification or documentation that were not established, whether they were submitted before the close of the window period of submission of land claims. I thought he's also gonna say the Rampe family, they can't just be making a claim. When you lodge a claim, you receive a reference number, which reference number becomes evidence on your side as the one lodging the claim that you have lodged your claim. In case the department is finding their own record missing, at least you can say the Rampe family, they said, here are the documentation that they presented to you. Then so that we know whether the culprit is not the community, but it is actually the department. So that's one point I've noted to say, I'm not hearing whether are you allowing them to show you their evidence, because it's a two-way process when we do lodgement of claims. But let me move on. In Northwest, the reason why their claims will never also be done with smoothly, we are dealing with a province where there is a Marinsky PGM, platinum group metal belt, that is running in Northwest, which is a bone of contention for the Big Five. Big Five of mining houses are there. So they are the ones who determine if those communities are in the way of the platinum belt. They make sure that they are dispossessed, they are moved, and they don't have a claim on the land. And they choose whom they decide who is supposed to be having actually a rightful ownership of the land. It is against that background I am raising the issue of the department having lost the references of Amakosi being the structure which they should be focusing on, because as communities were forcibly removed, they were scattered, and now you are dealing with a piecemeal individual community, and if they lose their claim on the department side, automatically that claim is deemed as lost. Whereas there is a reason why the claim was lodged. That's why I'm saying to the department, can't we use a reference of Amakosi wherein we're using the native tribes of Transvaal, because they tell you clearly before there was economic activities happening in that land, who are the tribes that were based there. Let me also register that there is something wrong we are doing in the land claim process, especially where the willing buyer, willing seller concept is working. In economics, we've got what we call opportunity cost. Opportunity cost means the value of the foregone opportunity. And in this case, I see as giving value to the one who dispossessed a person more than the one who was dispossessed, because they lost the value over a period of time. So those are the people who should be paid. But we came up with a policy which economically is flawed, because we are benefiting the same person who over time benefited in dispossessing the land and is also being awarded money to say, because now we have a claim against you, please, here is money, go. That process for me, I find it very disturbing. I'm happy on the issue of the Modimosana, Matlako, and Motau. You have discovered that the issue of the culture of the people cannot be resolved through a Western system. This is a royal issue, communities that were residing together, but the problem, the interventions we're using are Western. And that Western, the law of Roman, Dutch, and British law was designed to dispossess black people. They even use a term called no man's land. No wonder there is never gonna be finality on matters that touches our natives, because we are using a foreign law against our own, and then there's a deadlock. When there's a deadlock, how do you resolve a deadlock of a native law versus a Western system? But be that as it may, the issue of CPAs, I'm still saying it is a creation of the state, doing it deliberate to avoid Amakosi being returned into their land, and that must be put to note and it must be remembered. Then I also find it very disturbing. We are resolving AMA claims wherein we should be seeing more population of blacks being moved into their rightful areas. But in Northwest, I know for a fact, I saw big tracts of land, commercial farms, and we have now made it an excuse that if there is a commercial viable activity in that farm must be let alone because they are contributing to food security, as if that food they are producing there they are going to give to our people. They don't give to our people. When the whites took our land, they actually needed our land for trading purposes, and not just to trade for us. Yeah, they are trading for the international community. So they're exploiting our land for commercial gain. And if there's anything we are gaining from them, we have to buy it. It's not like we're getting it for free. And these are the things. On the matter of Lamusa case, I would like to find out from Mr. Matukane, in whose interest was the Lamusa case lodged? Because I find it very strange. Each time the people are seeking closure on their claims, the Lamusa case gets cited as a reason why claims cannot be undertaken, because understandably all the claims should be resolved first. But I'm actually worried that it could be that the same white people have actually staged this case so that it gives them more time to continue using the land while there is a deadlock that they're introducing in the legal case of a settlement of cases. Now you have a multiple process of old order claims and the new claims of 2014, and these claims are now on a standstill At the same time, they are making money on those farms. They are not progressing with claims, and there is a stalemate on whether should we proceed until we finish the claim. We were told in this committee that it's gonna take us about 5,000 more of claims that must be resolved, and you need billions to settle that. Why people who are sitting on our land are making those billions? So which means this money is available, but it is in private hands, and it's a mistake that we've done as the state not to handle this matter. So be aware as a committee that in Northwest, there is a conflict of interest in terms of mining and commercial farmers versus communities that must be returning to their land. Thank you, Chair.
Thank you, Honorable Nyambose. May I recognize the hand of Honorable Adams?
Good morning, Chair.
Good morning,
And-
Madam.
And good morning to the Deputy Minister and the department is what who is on the platform. Chairperson, let me also appreciate the presentations of this morning from the department. I will start with my questions. In slide 8, during a meeting, Chair, held on 28 February 2025 in Rustenburg, the following allegations were raised formally and responded to by the CPA committee members. Now the question is, how many meetings has the department, the CPA executive committee held in an attempt to resolve this matter? Mr. Sabolai proposed a meeting of 29 November 2024. The question is, did it happen? Meeting of 4 February 22, did it also happen? And in slide 13, the misuse of funds. Has the department conducted any investigation? Just one example from bank statements between 4th and 8th August 2024, expenses, and in Carltonville, ATM withdrawal of 5,700 Rand. For what was that? Wolmerenstad Butchery, 349 Rand 10 cents. In Carltonville, Wimpy, 900 Rand. And at a liquid store in Hartswater, 1,009 Rand and 29 cents. And then a large payment of 2,300. Chairperson, it would seem something was happening from Carlton to Hartswater. ATM withdrawals on company card raises crucial concerns. Similarly, purchases at liquor store, it could be water or soft drinks, but it raises suspicions. And then, Chair, on the slide presentation, there is a litany of complaints about mismanagement of CPA assets, such as lost laptops and the bakkie, which was already mentioned. What remedies has the department implemented in order to empower the CPAs to account for and protect its assets? I thank you, Chair.
Thank you, Honorable Adams. Honorable Ndalane.
Thanks, Chair, and good morning. And let me also take this opportunity to welcome the report from the department led by the Deputy Minister and the acting DG. Honorable Chair, I think the brief report on this case indicate that the land claim was lodged on the 30th December 1998 and was gazetted in 2025. And the question is that how is it possible that there are outstanding claims or portions that have not been restored in 2025. The other one is, how is it possible that the validity of the merit of the claim is now being questioned, and there is a view that 2025 research report is unclear? What is the legal or actual basis for the concluding that the report was unclear? And the last one was, has the Land Claims Court been approached with respect to the claim or complaints against Bafokeng and Land Court? If so, what is the status for now? Thank you, Chair.
Thank you, Honorable Ndalani. Honorable Matikizela.
Thank you, Chair.
Okay.
Thank you, Chair. Chairperson, my colleagues have partly covered what I wanted to say, because the biggest concern for me is the time it has taken for the outstanding land parcels to be resolved. One way or the other.
Excuse me, Honorable Matikizela, can you actually switch on your video?
Well, I'm trying to, but okay.
Well, if you are unable to, please continue. Have we lost you altogether? Honorable Matikizela?
Chair, I think he got kicked out, but he just entered now, joined the meeting.
Okay.
There you
are. There you are.
Are you happy now?
No.
Okay. So,
Chairman, Chairman, he was in pyjamas here to quickly run and get dressed up.
or perhaps he was still removing things.
Really, it is concerning for me, Chair, that it has taken so long to resolve this matter of outstanding claim. Because, if 743 people are sharing 4,000 hectares of land, while you have more than 6,000 outstanding, then it is a serious challenge. And I think I do want to understand where we are now with this matter. I've heard the explanation. And if there are these disputes between the valuers of the landowners and the valuers of the department, at what point do we really get to a middle ground so that we can finally resolve this matter, because it has taken too long, Chair? And also on the issue of disputes as to who are the legitimate land claimants, because I think as the presenter said, that this is now the third generation. I find it very surprising that is a problem at all, because if the verification was done 20 years ago, as he said, in 2005, surely when the new member of that particular family is born, then they just update the list of the people who are verified. I can't understand why it should be that difficult, because I think each and every family that is part of the beneficiaries, has a responsibility to update the list of beneficiaries as soon as a new member arrives. And you can just keep up the database of the people who are registered in that way. or better yet, I mean, what's stopping them to perhaps to do another verification if the last one was done 20 years ago? I don't understand why that is an issue. But Chair, I do want to suggest, I mean, we have a number of CPAs around the country, and it's not possible to reach all of them. But I think when a concern like this is brought to our attention, I think we have an obligation, Chair, to go and visit that CPA so that we can really engage those people directly, get facts directly, not only from the executive members, but from the beneficiaries as well. Because more often than not, as we have seen in some of the visits, the story that you get when we get these presentations become totally different from the story that you get directly from the people, Chair. So I think it's going to be important that this specific one, because they took, some time to raise this issue with us, I think we must really plan a visit to this CPA, Chair. It's my suggestion. And the last point I want to make, I think it's a broader concern that I have, Chair, because this constant concern or challenge that arise every time a new claim is discussed because of the Lamosa judgment. I mean, I think, Chair, there's high time that this committee really find a way, whether we approach the court with the department, we need to find a way to really now deal with this Lamosa judgment issue, because if you look at the number of claims that have been made since the Lamosa judgment between 2014 and 2016, they are more than double the old order claims. And maybe that should be part of the strategic workshop that we've been talking about. Because, colleagues, I get a sense that we just continue talking about these things with no really plan to deal with them from the department side. Because if the old order claims that were 80,000, I mean, it has taken now, this is the 31st year, it has taken so many years to deal with them. The new order claims, there are more than 163,000, which is more than double the number of the old claims, which means it will take us 70 years. And surely that can't be realistic. So we need really, Chair, to have a proper conversation and really agree with the department on how we're going to fast track the issue of land reform and which other players must come to the party so that we can really deal with this issue as quickly as we can, given the financial constraints that we have. Because with the budget that we have and with the time it took to deal with the old order claims, there's no hope really that South Africans will get justice, land justice, that we've been talking about for years. Thank you, Chair.
Honorable members. Hello.
Yes, Chairperson.
Honorable Matigizela, no, sorry, I had actually lost connectivity here. The next one would be Honorable Mkhaga.
Good morning, Honorable Chair, Honorable DM, honorable members, and everyone in the platform. Let me start with this one that I support, Chair. The Ramotlakane CPA.
Can you actually switch on your video, Honorable Khaha?
Hey, Diasbona ke Chair. I'm not sure yes, on your side.
Siyakubona Kaba. Good morning.
I'm not sleeping. I'm not sleeping. No, Chair, I think I must support the proposal of Honorable Matikizela. Why? Because the 9 allegations reflects a lack of support and guidance by the department to this CPA. And I hear the responses, but there are minute matters that I thought could have been avoided. And it's a question of laptops bought from second hands, talks to its disposal policy. The question of a vehicle that is stuck or in the state of disrepair, talk to your vehicle policy. And departments have those policies. And I don't understand as to why they wouldn't advise CPAs to adopt such policies as part of guidance. And I'm just citing that. The second issue is in relation to portion 0 outstanding that is challenged by landowners. I don't understand even this one, Chair, because commissions, office of the evaluator, and many offices have got powers to take decisions on some matters, and it can't be that the last word would come from the landowners after they've followed the law of the land. Because now there's a delay here of many years because of a dispute that could have been resolved earlier. Question one. The third issue is around the dispute lodged by Ms. Longwane. I'm not sure whether Ms. Longwane lodged this dispute on behalf of CPA or was just a lone voice in dealing with this. Perhaps a clarity here that needed to be worked. The basic thing here is around the hiring of independent election agency, which for me is a surprise because the intention of hiring this independent election agency was to ensure that the processes are smooth. But beyond the process, 2 people are challenged because of wrong elections to the CPA. Now, how does it happen? Where was the department when these elections were taking place? And more so because they've hired an independent body to monitor or run the election of the CPA. And that's why I'm saying the lack of guidance by the department in many instances here can be clearly identifiable. Yeah. The next question is in relation to what I don't understand. Claims between 2014 and 2016 cannot be dealt with due to court ruling and on the basis of legislative gap. Does it mean that the department is supposed to have initiated a policy as far as this matter is concerned in order to comply with the ruling of the court? Where is this process now? Because if this process is supposed to be presented to the minister is supposed to have intervened in dealing with this legislative gap that has been identified. But there's no way that people who have lodged complaints between 2014 and 2016, their problems, their claims can't be resolved because of a departmental problem or government problem. Where is this process now? My understanding is that the claims gazetted and settled, any dispute beyond that process is supposed to be brought before the court of the land court. And here I'm identifying that despite the people having chosen the option of land restoration, there are other processes that unfolded, trying to persuade people. I'm not sure whether they are persuading them to change their mind, but their original option was the land. And why now you do subject them to other options, and yet they've got their own original position? What motivated you to deal with such? I think that's a good. We've been always accusing the departmental officials that they are not assisting the land restoration process, restitution process, because they don't persuade people to actually choose land instead of money. And they are always denying that. But here I'm with an impression that here the intention is to persuade the people to change their mind as far as these options are concerned. But they have already chosen an option of land restitution. Why other processes now instead of following what they have decided on? The last one, Chair, is in relation to the verification of the list, because everything hinges on this question of verification. And seemingly, even by now, there is no credible list of beneficiaries. And that's where I'm saying, Chair, maybe it's important that we take that proposal of Mr. Matigizela to visit this particular province, identify other CPAs that have got problems, so that when we're doing this visit, we deal with those that are meant to be resolved as a matter of urgency. Because Northwest has got many farms, and our interest is to ensure that our people get their land in all provinces. So in order to respond to this other question, I hear the responses here, but some responses really raises eyebrows. Thanks, Chair.
Thank you, Honorable Mkhaka. May I please crave your indulgence, honorable members, time constraint notwithstanding, and allow Ms. Tongwane to please first respond to Honorable Mkhaka's question whether she actually raised those 9 concerns on behalf of the CPA, or she was actually doing so as a lone whistleblower. And secondly, to actually give her perspective on the submissions that actually have been made this morning, arising from her complaints. Thank you. I hope that Ms. Hlongwane is actually connected on the platform.
Honorable Chair, I don't know if you need to.
Honorable Matthias also, his end is up. Thanks.
I didn't see that. I'm sorry, Honorable Matthias. Okay, you are on the platform. You are on the floor.
Thank you so much, Honorable Chair. Greetings to colleagues and Deputy Minister and officials. Look, Honorable Chair, the risk of sounding a bit insensitive to the complainants, in particular.
Can you please switch on your video?
Honorable Chair.
It's hard to recognize you not in a red envelope, no, in a red costume. Okay, fine.
It's cold here in Cape Town, Honorable Chair.
Okay, Honorable.
Extremely cold. I thought Bloemfontein was cold, but I realize it's not as cold as here in Cape Town. Look, Honorable Chair, thanks once more for the opportunity. At the risk of sounding lacking agency to Ms. Hlungwane, who represents Ramotlakane CPA, and other complainants who represents Bakwena, Modimosana CPA, I'm likely to align myself with the proposal made by Honorable Mqitama and also Honorable Matikizela. But before I elucidate further on why I would propose that I align myself with that, but to mention, Honorable Chair, that there are 1,734 CPAs, registered CPAs countrywide, and most of these CPAs have got similar challenges. And these challenges are documented. Mrs. Hlungwane highlights those challenges in a letter of complaint to your good self, Honorable Chair. Just to repeat those would be in the interest of time. That's the first point. The second point, Honorable Chair, is that in relation to all of the claims that have been lodged and the landowners have rejected them on the basis of their parallel investigation, as a result, not acceding to the request for such piece of land to be restituted. The minister, in terms of the CPA Amendment Act, is empowered to invoke Section 35, subsection 5 of the CPA. And we ask ourselves, why is the minister not invoking that section? The minister and the deputy ministers might not be aware that they are empowered in terms of this section to invoke Section 135 to expropriate such piece of land, unless if the law passed by Parliament are just a luxury of members of Parliament to pass such laws which have got no effect whatsoever in law. That's the second point. The third point is that CPAs are a legal persona which is established also in terms of the CPA Act. And members of the CPAs, especially members of the executive committees of CPAs, have a fiduciary duty to act in the best interest of the CPAs. And it is in that regard that Mrs. Hlungwane has brought this matter before us. Perhaps officials must answer whether, in their own judgment, members of the CPAs, of these specific CPAs, are they really acting in exercising their fiduciary duties and acting in the best interest of the CPAs or not? Fourthly, Honorable Chair, when I want to go back to what I say, it may sound a bit insensitive and lack a sense of agency, is to agree with Honorable Matikizela that we need to visit these CPAs, specifically these two CPAs, and listen to the complainants directly about the problems they're faced with. But then more pointedly agree with Honorable Mqitama when he proposes that the CPA office with the register must be appointed, if it has not yet been appointed. And this, Honorable Chair, once more, the appointment of the CPA's office is provided in the CPA's Amendment Act, Section 2B, Section 2C, Section 2D, subsection A. Why has this office not been established? It ought to be established as a matter of agency so that it manages and regulates matters concerning CPAs, away from the involvement of officials who themselves are part of the entire value chain. They do research on the land claims. They approach and facilitate landowners on behalf of the department and on behalf of the land claimants. They strike deals in the process. They negotiate their own cards. And in the process, they get compromised. The sooner this CPA office is established, the better, because the register will be an independent, non-partisan person who has not been part of the entire value chain and act in the best interest of the claimants, and in that way ensure that these problems that bedevils the CPAs throughout the country are addressed structurally, meaningfully, in order to ensure that these problems are dealt with once and for all, and we don't have to be saddled with these problems on continuous basis, as is the case currently. Therefore, I agree that with Honorable Mketama that the CPA office must be established, Honorable Chair. And the rest of other matters, concerns which Mrs. Lungwane has raised and others, are painful issues, concerns and complaints that need to be addressed as quickly as possible. But the only structured way of dealing with these matters is to ensure that we have these processes in place. With those few words, Honorable Chair, I want to thank you for the opportunity. Thank you so much.
Well, thank you. Thank you very much, Honorable Matthias. Mehlongwane, we have a constraint of time, but nonetheless, I will allow you, not more than 5 minutes to first respond to Honorable Mkhacha's question, and also actually put forward your own perspective in 3 minutes.
Excuse me,
You are on the
Chairperson.
floor.
Excuse me, Chairperson. Chairperson.
Yes.
Excuse
Yes.
me. My
Is that
hand was up.
Honorable Van Wyk?
Van Wyk, yes, Chairperson. My hand was up. Just give me
Oh,
1 minute.
sorry. I'm so sorry about that. I'm so sorry, Honorable Van Wyk.
No problem.
It was actually not showing on my.
No problem, Chairperson.
Okay, no, thank you. You are on
Okay.
the floor before Ms.
Yes, I
Lungwane.
will just take 1 minute, Chairperson.
Okay, thank you.
I also want to just concur with Honorable Sematisi. I was also in Bloemfontein. It's my hometown. But Cape Town isn't as cold as Bloemfontein. So my apologies for the dress code, Chairperson. Chairperson, I just also want to emphasize and support Honorable Tikama with establishing a CPA office. I need to stress that is very important, because we have problems with CPAs from the Richtersveld, your Steinkopf, Kommagas, Pella, where you have ANC ward councillors and PR councillors, which is a fact. It's a fact that they serve on CPAs, not to serve the communities, but to serve their own self-interest, where you will find, like in Pella, just after Springbok, and in Pofadder, you have the second largest copper mine in the world, but the CPA there serve themselves and not the community. When you go to Pella, nothing looks like copper there, but they have the biggest copper mine in South Africa, just right next to Pella, on the land. So I think we have to identify these CPAs, and then we make a list, and they must be visited. We don't think we must summon them to Parliament. We must go and do oversight meetings, and we must go and look them in the eye, because they have serious questions to answer. Just last week, 4 individuals was connected to the CPA in the Richtersveld municipality, was released on bail, 100,000, 30,000 rand bails, because of their dealings through the CPA. The chairperson there has also resigned because of his dealings with their self-interest. We have problems all over South Africa with CPAs. Patani, Platfontein. So I just want to support it that we should make a list and we should go and visit the CPAs. Thank you, Chairperson.
Thank you very much, Honorable Van Wyk. You can then come in, Ms. Hlongwane.
Greetings to all. My name is Mapule Hlongwane from Ramotlakane, the Secretary of the CPA. Thank you very much, Chairperson, for the chance to speak. Chairperson, I would like to start by answering the question that was asked if I raised these issues by myself. I didn't raise the issues by myself. Firstly, I would like you to acknowledge that there's Mr. Tekiso, who was elected as an acting PRO, and we have a deputy chairperson who's observing with him in the same room. So, and also we have concerned members. It's a group of people. Although when we attend meetings, sometimes they are sent threatened messages not to attend a meeting, but we are about 57 in a group who are concerned about these issues. So what I would like to say is that there's someone who asked, I don't know if I was supposed to answer that, but it's a concern also for us, who asked if meetings were held on the 28th. It has been a lot of meetings. The activity plan that Mr. Gutele is saying, we have sat down with Mr. Gutele a long time ago. We sat down also with Mr. Manda Lugoto was in the minister's office. There were a lot of people from the department. And also on the 28th of February, we sat with Ms. Barati from the hotline. We also wrote to the hotline, telling them all these problems. Our concern is that we've been having these activity plans, but the department is failing to apply CPA Act Amendment 20 of 2018, Section 11, subsection 6, which states that if a person, whether a person from an association, I'll just highlight, if they have a concern or a dispute, an inquiry must be made. An inquiry was never made because we were never asked for documents. Like I stated there, Mr. Sibulai refused to take the bank statement from us. We had to send them to Miss Maledi there when we were sending the complaint. The bank statement, the chairperson approving his own lease contract with no rates, other white farmers getting lease contracts with no rates, not paying homestead, a treasurer leasing the whole farm alone of 500 and something hectares, no payments. And I would like to state that I did have a lease, but long time ago, and I paid. I have proof. There's proof. I can send the bank statement to the bank statement or the proof of payment to show that I was paying to Ramotlakane, and I was the only one who was paying at that time. So with that being said, Chairperson, I don't want us to waste other things. Our concern right now is that we can see that we are not getting help from the department. So we would like to ask you, say, that in terms of CPA Act, we have provided the bank statement. We have shown that annual audited financial report were never provided for. And also, Mr. Gutele just confirmed that they never got the audited. And our constitution clearly states that they must be provided. So is it okay for the community to just keep on running from 2018 till to date without we don't know. I'm the secretary. I don't have all the lease contracts. I have 5 lease contracts. We're selling pecan nuts. We have about 400 and something trees of pecan nuts. He didn't state that we're also making money from that. I don't even know how much we are making from. We have sheep. Sheep is being sold. We don't know the income of the sheep. So what we want to ask is that we have provided the proof, even the bank statement. The bank statement is only for that time. We never got the bank statement when we got into office. How much was when we started, when we resumed office, how much was in the account? We don't even know that. Even now, we don't know our financial. We don't know who lists. We don't know how much are they, who and who are paying, because the chairperson and the treasurer are refusing with the bank state with the lease contract. So our request is that, say, Mr. Tekiso, I think you won't be able to put an input. As you said, I'm only allowed for 5 minutes. Our request is that CPA Act Amendment 20 of 2018, Section 11. Subsection D says, on good cause shown having had the parties concerned, the registrar must dissolve a committee or relieve the committee members who did not, who it was proven that they were involved in a misconduct. So we are asking that we have provided the proof. We're asking for this committee to be dissolved. And then if it's not being dissolved, another option is that 5 of us in the committee, we are willing to resign, because we cannot continue in a committee where there is maladministration. We cannot do that. We want to resign, and then we are asking Chair that please help us to send that letter, because when we do it on our own account, no one is assisting us. So we would like to send a resignation letter to you. It's 2 options. We would like to send a resignation letter, or our resignation letters with the points that we will tabulate there, to ask the register to dissolve the committee, because the committee, it's 10 members. So if my 5 is not there, there's no committee. And also the quorum is made by 5 plus 1. So if 5 of us are resigning, we would like for you, the committee members, to assist us to ask the registrar to dissolve this committee. And then subsection DA says, and then they must appoint an interim committee amongst the members of the association. So in terms of our constitution, a special meeting can be held. So if possible, if the department is able, can they please fund us in that general meeting to inform the community that there's no committee anymore. The committee has been dissolved, and we would like for this committee to be dissolved with immediate effect, because money has been paid every September, every July to September, money is paid. So we've been in office for 2 years. We haven't seen that money of the lease contract. No one is reporting. Even that bank statement, for it to come out, we had to fight with the treasurer. Now we don't get along, because I was always fighting for this bank statement, and it was a 2-month bank statement.
Okay, thank you so much, Ms. Longwane. I'm sorry to have to do this to you, but fundamentally, you are actually requesting that the committee be dissolved, and that an interim structure be put in place. You are also requesting that the financial movement of the CPA be looked into, because there has been a lot of financial activities taking place which cannot be accounted for. Yeah. Can we allow now the department to respond? Honorable members, we still have the presentation by the department of the budget vote report. Okay, the Honorable Deputy Minister and your team. Honorable Deputy Minister.
Chairperson, I am not sure, maybe there's a connection error. Clinton Hyman, acting DG. Can I
the Honorable Deputy Minister and your team to respond?
Chairperson,
can you hear me?
Oh,
Honorable,
by the way, I must show my picture. So I'm not sure if I'm very visible.
Yes, you are, Honorable Deputy Minister.
Good morning once more, honorable members, guests, and members of the CPAs.
officials from the department. It is always very sad or saddening when you hear the kind of complaints that we are hearing coming from members of the CPAs. I hope, I just pray all the time that perhaps these differences members of the CPAs can get a way of resolving their problems, their differences, rather than reducing them to that level. So I'm not going to take your time, Honorable Chairperson. I'll therefore request the Director General and the team to respond to the questions. And then if there is any other matter of policy, I will always be available to intervene. Through you, Honorable Chairperson, can I request the Acting Director General to respond? Acting DG.
Thank you.
Thank you, Chairperson. Am I audible?
Yes, you are audible, Acting DG.
Thank you, sir. Honorable members, I'm going to ask that we start maybe with the DDG for Land Redistribution and Tenure Reform. DDG Ndove is on the line. And the questions that I specifically just want to ask him to look at is when we look at the oversight, and I think we start with the last item first, in terms of the acting registrar, that we start there, and then that he just takes some of the questions that are relating to the CPA, the amended CPA Act, and the establishment of the Office of the Acting Registrar and the actions that can be taken. We've heard Mhlongwane's plea at the end, and for me, that's the crux of the matter right now. So, DDG Ndove, can you possibly come in? Also, the Acting Registrar, Mr. Lokoto, is online, and I'd like you to deal with that issue, please, and then we can go from there. Thanks. DDG Ndove?
Thank you so much. Let me try also to make myself visible. I wonder whether members can see me, that I'm not a ghost, I'm also alive. Thank you so much. Thanks to you.
No, we can see you. We can see you.
Yes. Thank you so much, Acting DG, for allowing me time to respond. And thanks to the Chair, Honorable Chair, Honorable Deputy Minister, Honorable members, and colleagues, and also members of the CPA that are in this meeting. I think the details of the amendment, I'll leave them to the registrar to reflect on in terms of issues that have been raised that pertain to the work of the Office of the CPA. All that I can say with respect to what we have already presented also to them in our last appearance is that the amendment take into consideration that certain amendment may not be implemented immediately because of many other factors, including availability of resources. As you know, that this amendment the Amendment Act was asserted in September, October last year. Obviously, it was within already in terms of our planning processes in the middle of our 24-25 financial period. And again, it was also in the middle of our split. We have also indicated recently, and even before, that we still have to come up with the fit-for-purpose structure, and which the issue of the office of the CPA or CPA office needs to be considered in that process. What we have done up to so far is to appoint the acting registrar, who's the one who's going to talk after me, and also to get the deputy acting registrar in place. We also have in the process of, okay, that has happened as well, transferring some of the officials into that office while waiting to get the full-fledged office be established in terms of the Act. That's what has happened. So there is a constraint in terms of the available resources as we speak, but the plans to do that are in place. And I believe as and when we start with the fit for purpose, there will be a very clear indication as to how that office will be established. I fully agree that until such time we've got that office, most of the challenges that we have will not be resolved in a manner that will be speedy, independent, and also take into consideration that the amendment also give powers, as what was indicated by even Ms. Klungwana and the other members, as to what can happen in case where certain processes are not followed that are infringed of the Amendment Act. But again, you need to have that office functioning fully in order to also fully implement all the provisions of the Amendment Act. If you agree with me, Acting DG, can I allow the Acting Registrar to come in? Thank you.
Yes, Ms. Lakota, please proceed.
Honorable Chair, Deputy Minister, colleagues, and not to forget Ms. Songwane, who's the one who lodged this complaint. I just wanted to check, as everybody has been doing, I've tried to switch on the camera. I don't know whether it's visible. You will inform me. But in relations, I will just try to be very quick.
You are not visible. Sir, you are not visible.
Am I visible now, Honorable Chair?
No, but you may continue whilst you're trying to make yourself visible.
Okay. Honorable Chair, I will try to deal with issues that relates to the amendment. It's the biggest challenge with CPA that we need to acknowledge is that the Principal Act, which was passed in 1996, it didn't give them authority to the department to oversee the business affairs of the CPAs, which happens to be the crux of the matter in most of. There are two main issues which happens to be the main challenge of CPAs in all the CPA. It's an issue of verification and the use of business affairs. So the fortunate part of it is that in the new amended Act, there is a section that empowered the register to look after the affairs of them, business affairs of the CPA. The only challenge that we are still encountering now is that when you went to Section 18 of the Regulation 1B, it says that the minister must first develop regulation. So unfortunately, where we are now, we are at a stage that we have just finalized the regulation, their own route to the minister for approval. Then once the minister approves them, we are going to publish them for public comment. And then after that, it's going to be effective in terms of what is it that needs to be done. It even went further in terms of the banking details. If you look at Section 90 of the amended act, it even gives power to the register to even direct, to allow, we will then have to get into partnership with banks, because no CPA will be allowed to open a banking account without the authorization of the register of CPA. So these are some of the provisioning that have been put there to try to protect these CPA members that are forever fighting. But unfortunately, as we speak, those things needs those amendments to be effected in order for us to implement it. Now, when we comes to the termination of members, I thought that I need to talk to this, because one of them, the issue that was raised by Ms. Sungwane was that there were 2 members that were terminated, and the CPA itself, according to the presentation that was made by the province, was that they confirmed that they've terminated them. But unfortunately, in terms of the Amendment Act, Section 11A, it says that when you terminate a member of a CPA, you need to give reasons to the register so that the register can okay that. So I just want to say up front here to the committee to say, since I've started here 2-3 months back, I've never received a letter that talks to the termination of those 2 members. So I could safely say now that the termination of those members, depending on when it happened, because the Act only came into effect with effect from October. So if it has happened within that set, then it means it's illegal. But if it's not there, then we can look at it, because we haven't, as the office, we haven't received anything in relations to the termination of those members. And then the last thing that I want to dwell with was Ms. Sungwane has requested. She is correct that we are allowed by the Act, the register is allowed to dissolve a committee. But the Act clearly stipulates that this needs to be done having heard both parties. So I'm not going to have an authority of just listening only to Ms. Sungwane and say that we are going to dissolve that committee. So what we are going to do, I'm making a commitment. I will start engaging with the province so that we can start engaging the CPA itself, because as a register, I need to be upfront that I've never engaged the CPA. I've engaged in my previous capacity with Ms. Songwane and the committee where we agree on the map, roadmap, but that's where my involvement ended, because I was not dealing with CPAs now. But I'm making a commitment to the committee now that as the acting register, I will make sure that we engage the Ms. Songwane separate from this meeting and this group, and then we're also going to also engage with the committee outside of this meeting, and then we are going to make a determination. Because the unfortunate part of it is that if I just say that we are dissolving the committee based on what Ms. Sungwane has said, it can come back to haunt us, because I also need to have a reason that will be documented to say, I'm dissolving this committee because of this. I've engaged with all the relevant parties, and I've come to a conclusion that there is no other way that the CPA can proceed. So it's either I will dissolve the committee and come up with an interim committee, or alternatively, if it's worse, it will be an issue of putting the committee under administration. So I thought that I will just clarify those few things, Honorable Chair. But I'm making a commitment that I'm going from now on, moving forward, get involved in this matter and going to engage both the committee and the Ms. Sungwane so that we can find a way forward. Thanks, Honorable Chair.
Okay, thank you. Are there any further responses
There's many
from the okay.
Chair, I've got a list of 33 different questions that we've been able to capture. So on the following questions, I have sent the list now quickly through to the advocate. So on structural questions that spoke to restitution framework and policy, we had questions like, why are the claims being lodged between 2014 and 2016 not being processed? What is the current legislative process to address Lamosa judgment? What the department has done to comply with the Constitutional Court ruling. Does the department have clear internal policy framework to manage deferred claims? Why are the beneficiaries being pressured to change their restitution option from land to money? Is it economically justifiable to pay landowners who benefit prior to dispossession under the willing buyer, willing seller model? And why does the current land policy undervalue and the dispossess and reward the historically beneficiary of land grabbing? Is the department factoring the opportunity cost of land valuations and settlement offers? And why is the department not using historically tribal structures? I want Advocate Kane, please to answer those questions briefly. I know it's a long list, and then we will, after that, I've grouped the questions into the legal powers and failure of enforcement, and maybe that has already been discussed, but if we can just have those first set of questions answered, Mr. Matukane.
I would also really plead with the advocate to be as brief as he can possibly be.
No, thanks, Honorable Chair, and thank you also, Acting DG. I'll quickly just talk to, because I've grouped them as they were raised by the honorable members, but I think in that process, I will be able to deal with how you have structured them, DG. And so the first one was really on the lodgement of claims, whether or not we do give acknowledgements to the to the claimants as when they lodge, especially during the new window period of 2014 to 2016. Yes, Honorable Mthethwa, we do. In fact, we have learned from our experiences from the past. You know, even when we do site visits on the communities with our buses, we've got systems where if a person lodges the claim at the time, would actually capture all the details of the claim that they have lodged and would actually print an acknowledgement letter with the details of the claim that they have lodged and give it to the claimant. And so with the Rampe family, we've actually done that. And that is why we were able to confirm quickly that during the old order period, there were not claims that were lodged by this community. But yes, they do sit with an acknowledgement that during the 2014-2016 window period, there was, they have lodged the claims. Maybe also dealing with the 2014-2016 issue, Chairperson. Unfortunately, when the Constitutional Court handed down the judgment, they raised the issue of the procedure in dealing with the amendment bill because of the fundamental issue as raised by Lamosa was that the land access movement of South Africa was that Parliament did not consult adequately on the process. And so on that score, unfortunately, the Constitutional Court said that there was enough evidence to prove that that process, especially on the consultation on the bill, was not adequate. Hence, we were stopped from processing the old order claims. I'm with the Deputy Land Claims Commissioner in terms of, I'm sure he is better placed to respond to the issue on the processes that as the office is undertaking to actually pursue a process where we can get the process going on how we get to a point where the parliamentary process is reignited so that the amendment can be looked at, because the only way we can have this process, we can start to deal with this is when that process starts going, it's undertaken. The other one that was raised by Honorable Mthethwa was the issue of, especially in the Northwest, that the mining companies are actually dictating how claims should be settled. The good part with the Northwest is that we do not have a lot of claims lodged on the mining companies. I think we've got about 8. It is Ramatibela community, Barolombopoi, Bapwamogale, Bakatla Barampakong, Bakatla Barampakong, Ba Limpopo, and Barolombo Rapulani. Half of them are in the Bujanala district and the other are in Yakamudiri Molema district. What we do is once we have made research on those claims, we publish them. And in most instances, the mining companies, we know that they are protecting their interests, like Honorable Mthethwa has rightfully put it. They dispute the merits of the case. Unfortunately, the Act says as soon as we receive a dispute, that's the end of the engagement with the affected person. We are required to pursue Section 14 to refer the matter to the land court. So on all those claims, we have since referred the matters to court, but unfortunately, it's a process that is taking a little bit of time for the court to process all those matters. I think we've got only one, is Bakataba Rampakong, where the court says we are in agreement with the merits, give us an offer. We have since given them the offer. They have accepted the offer. But of course, they've got a mining license. They're saying that they're accepting on condition that the mining operations will still continue, which is something that the claimants have already agreed to. We are in the process of negotiating a settlement on the matter. I think that those are the issues that I think Honorable Mthethwa has said. On the issues of the willing buyer, willing seller, unfortunately, as the commission, we follow the Restitution Act, and currently it says that we have to commission evaluation and we must give an offer. But unfortunately, if the affected landowner disputes the offer, we do not have a choice but to end the matter and refer it in terms of Section 42E for expropriation. So those were the matters I recognized that Honorable Mthethwa has raised. The one that Honorable Ndalani has raised, it was on the issue of the fact that the claim was gazetted in 2005, and so why are we still having more than 6,000 hectares still outstanding to be settled? And I think we responded to it partly, and Mr. Kotaile also reiterated to it that in most instances, as soon as the landowner disputes the merits, unfortunately, we have to stop and refer the matter in terms of Section 14. But the reason why we have not referred here, particularly in Ramotlakane CPA, is because of, if you look at how these landowners were dealing with the matter, at some point they agreed to sell. We sent the memo. The memo was approved by the minister. Upon approval, then they were advised to retract their willingness to sell, and they said no, they are disputing the merits. So you always have these kind of landowners. That is why now we have taken a stand as a commission that as soon as we gazette and the landowner says, I am disputing the merits, we refer the matter to the Land Claims Court. Because of some of the landowners, what they do is, I'm accepting the merits. I hear you, you're saying the farm is valid. However, I reserve my right on the merits. Please conduct a valuation. Then the landowner would say, once he does not agree with the price, he says, by the way, I said I am accepting without prejudice. And therefore they go back to the merits, and it takes time. Now the strategy is that as soon as you need, before we even value your land, decide whether or not that you are accepting the merits of the case. And we hold you to that, so that when we give you the offer and you decide not to accept, then we expropriate in terms of Section 42E. The other constraint is purely on the issue of the budget. We have a limited budget as an office, and we can only settle. We're still sitting with more than 563 claims in the Northwest that still needs to be settled and finalized. And we have to spread our budget across all those land claims. And so we can only settle so much within a particular claim. And so definitely the issue of the budget comes to the issue. And I think that also answers the question by Honorable Madikizela. Why are we still having 6,000 hectares still outstanding to be settled? And of course, on the issues of the verification, Chair, I think we are taking note of the comments that have been made by the honorable members that we need to find a better way to deal with the verification because of one of the issues raised by Honorable Madikizela was that why can't we start from the beginning if it is a difficult process because of it was done 20 years ago in 2005. But the reality of the matter is that you've got different households. Once a new committee is elected, it comes with challenges. The members of that executive committee will be accused of not being the rightful beneficiaries. I think it is just the general nature of how people relate to each other when they are in the second, third, or even fourth generation because of they do not know they are the people who started this process, who, if they were alive, it would have been easy for us to solve the issue of verification. I think the other one by Honorable Mkhaga, it was on portion 0 that is being challenged by the landowners. Why don't we expropriate? As I've already explained, is that we only have two options as the commission. If there are dispute on merits, we have to refer it to court. And if there's a dispute on the price, we have to refer it also to court in terms of 42E. The unfortunate part in this instance is that the current research report that we are sitting with, we do not believe that it will stand the test of time when it gets tested by the legal representatives of the landowners in the land court. Hence, the current researcher is tightening all the loose ends to make sure that once we refer in terms of section 14, we are able to make sure that we are having a winnable case at the court.
Can you please wind up?
I think
we are really hard up for time now.
I think I've already tried to summarize most of the questions because of others are just overlapping on the issues that I have already responded to, Chair. Maybe let me pause there for now. Thank you, Chair.
Thank you. If there are still any outstanding responses, please can you submit them in writing to our committee secretary? Then we will be able to consider them as a committee. I'm so sorry to do this because we still have two other items to actually look at. The very substantive one is the budget vote for report for the department, and also some other issues that we need to actually look into. Honorable Deputy Minister, would you like to say anything before we close this particular subject?
No, I think I'm fine. I'm covered.
Thank you. Honorable members, we seem to be having.
Chairperson, excuse me.
Yes,
For
Honorable
interjecting
Rambe.
Yes, Chair. Excuse me for interjecting there. Can the department, especially our DM or the acting DG, please respond? Are they supporting a list from us to identify CPAs that we should have meetings with and oversight visits? Do they support it? We didn't hear anything about that input. We want them to give us a straight answer. Are they supporting the oversight with CPAs around the country? Thank you. Thank you.
Well, thank you, Honorable Member. I don't think it is up to the department to decide which CPAs to visit. I think it's us, the members of parliament, who should
don't need
actually.
Their permission.
We don't need their permission. We need just to agree find the date and then communicate that to them, and then we go there. Yeah, if that is agreed, we don't have to actually get their permission to do so. Honorable members,
Thank you very much.
I do want to really wrap up this discussion by actually saying that there were two very sharp, proposals that came up. One is the one that we are talking about now, the proposal to visit the CPAs. I'm sure as a committee we will have to decide when we want to do that, because there was sufficient consensus that we need to actually visit these CPAs as a matter of urgency. The second one was the establishment of the CPA office. There was the firm proposal that this actually be done as a matter of urgency. And looking at the problems that bedevil the CPAs right now, there is, any further delay in the establishment of this office would actually render the whole process of land reform in this country completely, useless and in disarray. I was concerned to learn that Ms. Hlongwane is actually also part of the consent group in that particular CPA. Honorable members will remember that wherever we went, so we have been so far in terms of our oversight visits, we have actually met, consent groups in Mpumalanga, be it in Mpumalanga, be it in KwaZulu-Natal. So it would appear that the phenomenon of consent groups is actually everywhere. So that actually warrants to expedite the establishment of the CPA office to deal with these issues, because these consent groups are actually mushrooming everywhere because of certain issues that actually they are experiencing in their daily operations in the CPAs. There was a talk about the regulations that are being processed right now, and I still hope that the department would actually provide us with some kind of a roadmap as to when this process will actually be accomplished, because very often we get to be told about processes that are underway, but we never actually been given the exact time frame within which those processes will actually be accomplished. And the dissolution, the acting registrar actually said can only be done after having heard both parties. I so wish that we could actually know exactly when he will actually be hearing the other party, so that this actually dissolution can be effected without any further delay. Because I don't want to sit here next year and still be hearing about a dissolution that still has to be done because the other party has not been heard. Honorable members, on that note, I would like to go back to the department and allow them to actually do the second presentation relating to the budget vote. Thank you.
Sorry, Chair.
Yes.
The budget vote report is on us. I think Chair can release the department.
I didn't get you. Hello? Committee Secretary?
Hello, Chair. I was saying that the budget report is on us. The content advisor will do the presentation, so the department can be excused, Chair. Thanks.
Okay. No, thank you then. Thank you then for that advice. So the department is excused, so that we can actually continue with our business. Thank you.
Thank you.
Thank you.
Thank you.
Thank you.
Dr. Manenze, are you ready to lead us on this one?
Thank you, Chair. Good morning to you and to honorable members. I see that we do not have enough time. Chair, I will be guided by you, but I was suggesting, okay, let me just show what we have and start discussing here on page 35. I'll just quickly scroll through from page 1 that shows the process with the introduction and showing who we have met, the department and the entities that we have, which is the commission, the OVG, the ITB. And really this was about assessing the key priorities and how they align with the NDP. And then we introduced the department, its strategic goals, and what the work of the committee really was focused on in this process of considering the budgets. This table, it tries to show how the outcomes are aligned with the medium-term development plan, and also indicators also what the 5 years targets are. This is a list of legislation to be tabled that is in this financial year, which the committee must track. We have to for 5, but also other amendments. It is important to note here that the priority legislation, equitable access to land bill, is included. Other amendments relate to land administration, planning profession, special data and special planning and land use management. 2 policies, you will see these 2. They've been in the making for a very long time. And then we begin throughout, you will notice that the report kind of indicate a committee responses. This is where we factor in comments and inputs that members have raised. You can think about a comprehensive review of overarching legislation or legislative framework. Then we look at the overview of the allocations. This is the tough stuff that we have, and we have seen from the presentation. We are summarizing it. We tried in this table to actually show, program and the sub-program and allocations. These highlighted one is the current financial year and the outer years, and you can see the total budget over the medium term. So we looked at the administration, some illustration of how budget has been split, program 1, program 2. In each, members would have also noted that we do highlight the observations. So it goes program 3, then program 4 about rural development, and then within entities, ALA with the allocation there and there. Then we did the public entities, the commission, though it's not yet fully, well, in law it is independent, but in practice it's not autonomous. So we do include it as public entity there. Okay, let me quickly go down. This is the Office of the Valuer General. TB. Try and show the budgets. Then, having in section 6, having looked at the deliberations, presentation, budgets, APPs, and considered all those observations, the committee drew the following conclusions for the department. It is a committee noting that what the priorities are: acceleration of land reform, finalizing restitution claims, creating rural economic opportunities, investing in rural infrastructure. So under administration, one, in terms of the conclusions, and we are highlighting this so that we can then link the recommendations with these key conclusions of the committee. One was that the reconfiguration of the Department of Agriculture, Land Reform and Rural Development, resulting in a split into two, that is agriculture and land reform and rural development, exposed this department to leadership instability, with several senior management positions remaining vacant. Those are the Director General, DDG, Corporate Services, CFO, and other. These high vacancy rates have negatively impacted service delivery and hinder clarity on the strategic direction, especially in the absence of finalized fit-for-purpose structure. I think by now, every meeting we hear about fit-for-purpose structure, even with the discussion about CPAs. So, although the departments align with strategic government outcomes as outlined in the MDTP and the NDP, the decline in budget allocation risks undermining its ability to deliver on land reform and rural development, both critical to addressing rural-urban migration and economic linkages, redress apartheid special designs and unequal land ownership patterns. It's an observation about budget decline in allocation. Department's legislative program, which I showed up there, includes the Equitable Access to Land Bill and Communal Land Tenure Bill. It lacks clear timeframes for tabling in Parliament. Yes, they've been included, but nobody knows when they will be tabled in terms of what they have in the plan. This weekend's parliamentary oversight and could hinder legislative progress if these bills, well, I think here we wanted to say, if the equitable access to land is not tabled, it could be a setback to Parliament in light of litigation against Parliament for failing to enact legislation under Section 25(5) of the Constitution. Many targets set for key performance indicators, including jobs created, hectares allocated, restitution claims settled, infrastructure delivered, are too low. In some cases, even lower or below baseline levels. This risk presenting misleading favorable performance outcome while failing to meet the transformational targets of the NDP. I think honorable members will remember them, questioning the low target, but also linking that with the budget. The next one, department continues to face material irregularity issued by the Auditor General, mainly approximately these 530.5 million, arising from RECAP, that is the Recapitalization and Development Program, reconciliation, and failure to account for funds dispersed to land reform beneficiaries. Further, it continues to incur irregular, fruitless, and wasteful expenditure due to weak internal controls. These recurring issues threaten the department's ability to achieve unqualified audit outcome as planned. Under land administration, ongoing disputes between government and traditional leadership over the implementation of SPLUMA risk compromising land use planning in areas under traditional authorities, potentially rendering municipal planning ineffective. Any amendment to SPLUMA must address underlying concerns rather than appeasing stakeholders superficially. So in a way, committee making like a plea that there should be meaningful engagement. While the recent land audit is a positive step, it lacks depth in ownership, demographics, corporate land holding data. A comprehensive disaggregated land audit, especially of state land, owned land, is essential for enabling proactive land acquisition and redistribution to redress the skewed patterns of land ownership. Under administration, a fully functional EDRS, that is the electronic deeds registry system, is a huge improvement in deeds registry in South Africa, which could improve efficiency in the deeds registration processes. For land reform and restitution, the committee here says the department's total allocation of 9.8 billion with 6 billion earmarked for redistribution, tenure reform and restitution constitutes only 0.3, it's 0.3 or 0.4, 0.3 of the national budget. This reflects a long-term decline in funding, and it's unlikely to assist the department to meet the NDP 2030 targets to acquire land, 30% of wild-owned agricultural land, especially given rising land acquisition costs. The next one here is an observation, or let's say a conclusion, that combining redistribution and restitution under one program obscures the specific contribution of each and undermines the distinct constitutional basis for equitable access in terms of Section 25(5) versus restitution, which is in Section 25(7). This structure also compromises autonomy of the Commission on Restitution of Land Rights. Real terms budget cuts in redistribution and tenure reform undermine efforts to implement key legislation such as ESTA, extension of security of tenure. I'll have to write them in full. Extension of Security of Tenure Act, Land Reform, Labor Tenants Act, Interim Protection of Informal Land Rights Act, the Transformation of Certain Rural Areas Act. This has a negative implication for monitoring and preventing farm evictions, settling labor tenants' claims, the protection of informal land rights, including on the Ingonyama Trust land. While incorporating post-settlement into the department is a step forward, the lack of role clarification among various departments risks duplication of efforts, inefficient use of resources, double dipping by beneficiaries. Auditor General findings have highlighted challenges in financial accountability under land development support, which needs to be addressed in the new post-settlement model. Perennial grant funding risks creating long-term dependency among beneficiaries. A clear exit strategy for grant recipients informed by regular assessment of the capacity, sustainability, and commercial viability of the supported farmers or producers is vitally important. The strategy should address, among other issues, criteria to determine when beneficiaries are able to operate independently alongside traditional support mechanisms to ensure continuity and resilience. The slow pace of releasing unused state land and public land hampers land reform efforts. A credible, up-to-date land in the database of state land is urgently needed to facilitate redistribution. And this can be linked to the issues around audit, especially of the unused or vacant state land. Ongoing training of CPAs has shown limited impact due to persistent capacity constraints in the department. Despite recent legislative amendments, CPA continue to face operational challenges, partly due to their being used for functions beyond their intended landholding role. Measuring land redistribution performance by hectares alone is problematic due to South Africa's varied agroecological conditions. A hectare in one province does not equate in economic or productive value to a hectare elsewhere. I think you'll remember this discussion about Northern Cape and Western Cape or Mpumalanga. Underlying design of land redistribution based on market-led approaches was possibly not intended for delivery of land at scale. Current policy fragmentation between land reform and rural development must be addressed through a holistic agrarian transformation strategy, to which land reform is a constituency part. This calls for a land policy review. That's a conclusion there. In terms of rural development, rural development budget for the department is insufficient for a meaningful impact. A coordinated approach involving other departments is essential, with the department repositioned as a catalyst and a coordinator rather than a project implementer. It would require the department to refocus its mandate and purpose and let other relevant government departments with budgets for rural development implement programs under the district development model, where the department would play a critical role alongside cooperative governance and traditional affairs departments and municipalities. Youth employment continues to rise, yet the intake of NARISEC has declined, raising concern about government priorities regarding youth empowerment and development. With regard to the commission, the observation, I'm really running very fast. I hope members are following. The commission's long delayed transition to a fully autonomous entity like a Schedule 3A public entities has not materialized. It continues to function as a sub-program of the department, contrary to the legislative intent under the Restitution of Land Rights Act. The commission operates at only 50.7% of its approved staff complement due to failure to finalize and implement its organizational structure. The effect of this is that it is constrained to improve its performance, and a few staff in the commission are overstretched. With the 3.7 billion allocated, the commission lacked sufficient funding to settle the 5.4 thousand outstanding pre-1998 claims, or what we call old order claims. At the current rate, I think this is cited many times, it would take 30 years to finalize this claim. The projected 129 billion needed over 5 years is unrealistic without significant budget increase. Unless the old order claims are settled, the commission is unable to start processing new order claims unless the court direct otherwise or parliament passes legislation to that effect and giving legislative government on how new order claims, about 160,000 plus, could be dealt with. The auditor, the Office of the Valuer General, 3 issues were raised by members here. It's about the prolonged varied vacancies in the CEO and CEO positions, spanning 7 and 9 years respectively, have led to leadership instability, delays in decision-making. Further failure to appoint officials could have created a challenge because of a legitimate expectation for absorption into these positions by the incumbents. Data present to the committee indicates that the OVG has begun applying valuation methodologies aligned to Section 25 of the Constitution, enabling land acquisitions below market value where appropriate, in line with the just and equitable principle. The office has indicated readiness to support expropriation act through its valuation methods. However, additional capacity, especially accredited property valuers, is needed to meet the APP target for issuing valuation certificates. With the Ingonyama Trust Board, 4 issues, the ITB operates at the intersection of statutory law and Zulu customary law as outlined in Section 24 of the KZN Ingonyama Trust Act. Legislative reform is required to address the recurring governance attentions. The replacing the board without such reform will not resolve systemic issues. While ministerial oversight has improved, further support is required to ensure that ITB adheres to good corporate governance, especially in relation to court orders. Here we mentioned KSAC or KASAC judgment, mandating and processing secure tenure. And I think here we can think about the legislation, Chapter 11 which was mentioned, that is the, which, that of my mind, but it's chapter 11 of it. I'll find that we do include it in the report here, where it creates this dual authority in terms of transaction on the land, the Ingonyama Trust and the minister. It's in the CASAC order, listing the trust in the PFMA as a Schedule 3A entity, and the board only operating as its accounting authority could clarify accountability concerns that the portfolio committees have raised since the 5th Parliament, demanding accountability of the trust and not the ITB alone. It would also compel all the subsidiary companies, including the Ingonyama Holdings, to account to Parliament. The introduction of rural development function within the ITB, including disbursements funded by the cash reserves, is a positive development. However, its success will depend on coordination with local, provincial, and national stakeholders, including COTA and the House of National, provincial, shouldn't be national, provincial House of traditional leaders. Apologies there. Then we move to recommendations. Chair, shall I move on, or maybe members want to make reflections if I have missed something, or maybe added things that shouldn't be here? Shall I proceed?
Yes.
Okay.
Yes.
Okay. So recommendations. The committee recommends that the Minister of Land Reform and Rural Development must, under the Department Administration Program, urgently ensure that the department must fill critical senior management posts, particularly at DG, DDG, and Chief Director levels, in order to stabilize leadership and ensure effective implementation of the department's mandate. Ensure that the department must finalize and implement the revised fit-for-purpose organizational structure to improve operational efficiency and service delivery at both national and the PSSC, that is the provincial shared services center levels. Set realistic performance targets aligned with NDP 2030 to avoid a culture of mediocrity enabled by low targets that do not reflect the scale of land reform required. The department must submit clear time-bound plans for the implementation of the legislative program, including tabling of legislation in Parliament, especially the Equitable Access to Land Bill, the Communal Land Tenure Bill. Further, the department submit quarterly reports. This would be progress reports on the implementation of the legislative program. Strengthen internal controls and consequence management to address recurring audit findings, including material irregularity, irregular, fruitless, and wasteful expenditure, particularly those flagged by the Auditor General of South Africa. With regard to land administration, ensure that the department must lead inclusive dialogue with traditional leaders to resolve ongoing tensions around SPLUMA implementation, and consider amending legislation to provide clarity while maintaining constitutional planning principles. Conduct a comprehensive disaggregated land audit, including demographic, use type, corporate ownership data, especially for both private and state-owned land, to enable proactive land acquisition and redistribution. It is vitally important to know what property was being used and what was not being used, and which is abandoned or hijacked. Land reform and restitution. As executive authority, the minister must engage with National Treasury with properly motivated increase of budget allocation for land reform, especially for redistribution and tenure reform, as well as the restitution, to levels that make meaningful progress towards NDP targets feasible, and to be able to meet the obligations under court orders in terms of LAMUSA, Molase, and others. We might as well include CASA here. Separate redistribution and restitution program structures and reporting lines to reflect their distinct constitutional mandates. Here we refer to Section 25(5) and Section 25(7), and uphold the autonomy of the Commission on Restitution of Land Rights. Consider initiating engagements with Minister of Public Works and Infrastructure about fast-tracking development and publication of the implementation regularities and guidelines for Expropriation Act. The minister should report quarterly to Parliament on progress towards operational readiness of using the Expropriation Act as a tool to fast-track redistribution. I think members were agreeing this on the basis of the budget cuts. Ensure dedicated funding is allocated for coordination and implementation perhaps of tenure reform, including implementation of ESTA, LTA, IPILRA, and TRANCRA. A special unit may be required to prevent continued evictions and ensure protection of vulnerable rural population. The minister is further requested to submit by September 2025 an addendum with clear outcome indicators and target in relation to tenure reform as indicated in this report. This report says the committee looked and couldn't find targets for these area of work. The department must clarify interdepartmental roles for post-settlement support to prevent duplication with the Department of Agriculture, ensure targeted, coordinated support to land reform. Further, the minister must submit a report within 2 months of the engagement with the Department of Agriculture about post-settlement support roles and responsibility, as well as policy mechanisms to guide its implementation. Fast-track audit and release of unused and underutilized state land. The department must quarterly report on the availability, condition, and status of the state land earmarked for redistribution. Restructure support for communal property association by fully capacitating the CPA office, enforcing the CPA Amendment Act, and avoiding the use of CPAs for commercial or administrative roles beyond their intended purpose. I think this links with the discussion we had this morning. Review performance indicators for redistribution to include productivity and viability, not merely hectares transferred, considering varying ecological zones. Initiate a comprehensive policy review to integrate land reform into a broader agrarian transformation framework, addressing structural limitations of the market-led model and aligning with food security and rural development goals. 2 issues for rural development or recommendations. Departments must redefine its role in rural development as a coordinator and a catalyst, ensuring synergy with other departments and state agencies to maximize developmental impact. The committee was saying, well, you can't keep on doing everything and anything. You really need to zoom into what you do best and let other people do other things. Review and expand on the NARISEC program, ensuring increased rural youth participation and meaningful upskilling in alignment with national youth employment strategies. For the Commission, Minister should ensure that he expedite the formal transition of the Commission into an autonomous public entity, Schedule 3A, with full operational and financial independence as envisaged in the Restitution of Land Rights Act. Just added this. Further, submit a time-bound plan to achieve this recommendation, basically. Approve and implement Commission's organizational structure, filling critical posts to reach full staff complement and improve claim processing capacity. Ensure that National Treasury and the Executive Authority must develop a multi-year restitution funding plan, including prioritized budgeting or budgeting for outstanding pre-1990 claims, supported by legislative amendment to enable processing of new order land claim. The Office of the Valuer General members, strongly urged the minister to urgently appoint a permanent CEO and CEO to restore leadership stability and accountability in the Office of the Valuer General. Further, so 3 months. The OVG must scale up recruitment of accredited valuers and streamline systems to meet valuation certificate targets. Ensure continued use of valuation methodologies aligned with Section 25 to support acquisition and expropriation processes based on just and equitable compensation. The last one is the Ingonyama Trust. Amend the KZN Ingonyama Trust Act to clarify interface between statutory obligation and Zulu customary law, thereby addressing long-standing governance tensions. Strengthen oversight by the minister in this department to ensure that the ITB complies fully with court orders, particularly relating to the protection of tenure security for beneficiaries. List the Ingonyama Trust as a Schedule 3 public entity and designate the board as accounting authority to improve accountability to Parliament and ensure oversight of all subsidiaries, including the Ingonyama Holdings. The minister should provide technical and financial support for the ITB's rural initiatives, ensuring a collaboration and with provincial COPTA and the provincial house. And Khoisan leaders. Sorry about that. So that's the end of it. We conclude by saying that the committee further recommends that within 3 months after the adoption of this report, they invite the National Assembly. The minister should submit a report that tables responses and progress reports in the implementation of the above recommendations. And this report is for consideration by the National Assembly. Thank you, Chairperson.
Thank you so much, Dr. Manenzi, our content advisor. Honorable members, your comments, please. I'm ready to recognize hands.
First Pagame, Madam Chair.
Nyambose, whose other hand is up.
It's mine, Chair.
That's Honorable Matigizela.
Yes.
Okay, Honorable Chair. Who else is there? Who is the iPad? Is that Honorable Matigizela?
Yes, Chair. That's Honorable Matigizela.
Okay, who else? Whose hand is still there? I have two members here that I have whose hands I have recognized: Honorable Matigizela and that of Honorable Mtetwa.
And Honorable Mutama, Chair.
Honorable who?
Mutama.
Honorable Mtala, who is that?
Mutama, Chair.
Oh, Mtama, okay. Mtama, okay. Any other hand? Okay, Honorable Mtetwa.
Thank you, Chair. Okay. I'm noting the following, that the issue of land reform is a legacy of the British government since they colonized us. And I have also studied after 1913 Land Act as to where did these land pockets go to, which they took from Amakosi. I've identified then those who are involved in being the beneficiary of this land. I identified the British government to be a beneficiary from 1910. I've identified the apartheid government in 1948. I've identified the democratic government in 94. I've identified the mining houses amalgamated, and then the property associations. I've identified service delivery council municipalities. I've identified Sandral. I've identified commercial industries. And all of these to be the beneficiaries of the land reform when it was taken from the natives. These people, they benefited, which then tells you who are the people who should contribute to the fund of restoring the land and reform in South Africa. It is all the stakeholders I've mentioned. So for us to cover the 129 billion, this money I have calculated and have realized it is being made on daily basis by these entities, but it is sitting in private hands. So we must find a way to get these people to pay back, because they are paying back for the suffering they've caused on the natives who are now today without land and they don't have factors of production. As a result, they are viewed as poor, but when you look at their land, it is these people who are occupying it. So in that way, we'll be able to balance the ownership patterns, and we must also change the manner in which we then ensure that ownership patterns of land are actually equitably shared, because we've observed from 1913 until 2025 that nothing has moved, which means the system we're using is wrong, the legal framework we're using is wrong.
I've lost you, Nyambose. I've lost you, Nyambose. Okay, Honorable Matikezela, in the meantime.
No, thank you, Chair. Thank you, colleagues. You can see me, ne?
Yeah.
Chair, thank you, Dr. Manenza, for this summary of the recommendations. Obviously, there's a lot to be said about this department, and a lot was said when we discussed the medium-term plan and also the APP. I do want to recommend, Chair, because I think if you look at the first recommendation on the administration, my suggestion is that the first bullet must be the second bullet and the second bullet must be the first bullet.
On the recommendation.
Yes, on the recommendations. Dr. Manenze, my logic with that is that before we fill any positions, the department must first come up with a fit for purpose organogram or the organizational structure, so that we can also understand the mandate of this department vis-a-vis the organogram, and then see what positions need to be filled against the mandate of the department. I hope that makes sense. On the second, now I'm moving to land administration, Chair.
Yeah.
Now, on the land administration, I think one of the things that is missing in terms of the recommendations is the prioritization of the deeds office, because if you look at the allocation on the deeds office, if you look at the APP, there is zero allocation throughout the MTEF period. And if you look at the report, there is a 1% allocation. Yes, of course, I mean, that 1% for me, given the fact that the department is looking at moving to electronic system, I'm not sure to what extent that 1% can really assist, given the fact that, you know, most of the deeds office are in serious trouble. They are operating under serious constraints, and that has a huge impact in the property registration. And the minister also now is busy with a policy to force people to register according to their race. I mean, whether we agree with that or not is another matter, but there's a lot of work that needs to be done in the deed office, and therefore I recommend that that should be one of the priorities that we force upon the minister. And obviously, on my last comment is that on the Ingonyama Trust Board recommendation, I agree with the amendment of the Act to clarify the interface. But also, I think we must even go further, Chair, and make sure that we comply with the intentions of the formation of the Ingonyama Trust, where people really becomes the beneficiaries of their land, because that's not happening currently. Let me stop here, Chair. Thank you.
Thank you. Honorable Mqetama.
Thanks, Chair. Chair, I will withdraw my comments until you call for the administrative question around whether we adopt this report or not. Thank you.
I'm actually almost there because of the constraint of time and the fact that there are no additional hands that I can actually see. So I'm actually now calling upon the proposal for the adoption of the report with amendments.
Chair?
Yes.
Chairperson?
Yeah, yes, yes.
Apologies.
Dr.
Before
Mnatha.
you call for the adoption, there's one. Okay, there are two proposals here which are not being reflected here. Honorable Mthethwa speaks about these the budget for restitution and how the state can actually raise funds for that, and he's arguing for private sector contribution. So as members are going to adopt, I want to say we are going to include the Honorable Mthethwa's proposal that there be a private sector fund. So the minister to consider that and develop mechanisms around which private sector can make a contribution. There was a proposal like that in the past, and it was a recommendation from this committee in relation with I think the discussion was about the stock exchange, but members agreed that it should be broad enough for private sector contribution. So I think we are going to reiterate that in this report if members agree with that recommendation. On the issue of the budget, sorry.
Yes.
On the issue of the budget,
I was going to say that it was a proposal, if my memory serves me well, that actually was made by Honorable Mqetama initially.
Yes.
That of the Johannesburg Stock Exchange involvement, that it must be approached to finance this program.
Thanks, Jess. So there's nothing wrong with members putting it back again. So sometimes when recommendations are being drawn, there's nothing wrong in bringing back. It shows that the committee is grappling with that issue. We have to bring it back for minister to engage with that. And I think that idea, it's not far from the idea about developing a land reform agency, more about private sector contribution. But it's been talked about for a long period of time, but not tangible. So bringing it back, the committee is really trying to get the minister to engage around these issues. The question about the deeds office, members should remember that the deeds, for lack of a better word, it generates its own revenue with the payments that they, and I think the head of the deeds did mention that. So that's why you will see that it will show zero or nothing. It doesn't mean that neglected. It just means that it generates its own fund. That's the model with which it has been operating all along. I'm not too sure what I hear is that Honorable Madikizela is saying that these offices are struggling across. So is it the motivation that over and above that, there has to be some, minister should consider creating some kind of a transfer, just like the minister does to the Ingonyama Trust Board. I'm not saying it should be given 22 million. That kind of an approach to deal with all these other challenges. I think that's also given the funding constraints. I think that's what members should clarify for us so that we get it clear. Thank you.
Well, thanks, Doc. I think the head of the deeds office actually did herself a disservice in this regard, because she actually, from what she said, was that they are well off. I didn't get the outcry for additional financial resources to be able to do XYZ from her contribution, but perhaps it was just an omission. Honorable Matikizela?
No, Doc, thank you for that clarity. Unfortunately, on the report that is presented, that narrative is missing. To say that the reason why the deeds office is not allocated, it's because it generates sufficient funding. Because I hear what you're saying, and I wouldn't advocate for more money being given to deeds office. Maybe a better management system must be introduced to deal with the challenges of deeds office. If they generate enough money, then I think really they should manage deeds offices better across the country, because most clients that I'm dealing with are really complaining about the situation. The classic example is the Johannesburg office, the deeds office in Johannesburg.
Yeah.
That office is falling apart. It's virtually impossible for people to work from that office. So the arrangements are being made for it to be relocated, but that is something that has been going on for years. So maybe, Doc, then that is what I'm really calling for. Thank you, Chair.
Okay, thanks.
Well, thank you, honorable members. With that clarity been given, is there any proposal for the adoption of the recommendations and the report with amendments? I don't see hands. The Secretariat I will ask them to help me identify hands.
I see a hand from Honorable Mutama and Honorable Matikizela, Chair.
Okay, Honorable Mutama.
My hand is to register the objection to the adoption for the MK party.
Okay, and Honorable Matikizela.
Chair, after engaging the report when it was presented and the discussion that we had now, one is cognizance of the constraints that the department is facing. And also we have raised our concerns with regard to the department. But the report itself, after our input and our engagement, I do agree that it must be adopted, Chair. Thank you.
Thank you, Honorable Matikizela. Any seconder?
Second, Chair.
Honorable Mkhakha?
Second, Chair.
Oh, thank you, Honorable Mkhakha. I hope the position of the MKP will actually be noted. Thank you. We have our last item, the adoption of the outstanding minutes.
Yes, Chair.
We have, hello, Cynthia, the acting secretary of the committee, are you going to lead us on this one? Which minutes do you want us to adopt? There is a set of minutes for the 21st of May and the 28th of May, et cetera, et cetera. Okay, honorable members, we have a set of minutes for the 21st of May.
Chair?
Yes.
I move for the adoption of the minutes of the 21st of May.
Any seconder? Can I be assisted to recognize the hands? There is a hand up. I don't know whose hand is this.
Honorable Ngutama, Chair.
Honorable Kutama. Honorable
No,
Kutama.
Chair, no, that's a legacy hand. Sorry.
Okay.
Oh, okay.
I second, Chairman.
Okay, thank you, Honorable Nana. Okay, let's move on to the set of minutes for the 28th of May. Any proposal for the adoption of those minutes?
Chair.
Any proposer?
Chair,
okay,
this is
Honorable Matikizela.
Chair, bengicela ningagezeleki kwaba bantu babhala minutes. If you look at these minutes, the attendance by committee members, I have no initials there. I have nothing. It's just Matikizela. What is that? There are so many.
Yes, indeed, there are so many Matikizelas that I know of. I think it was an omission that must be rectified. I can't hear. Somebody is actually talking. Who is that? With that amendment, is there any seconder? Honorable Mkhakha, do you want to second?
Nana seconds, Chairman.
Thank you, Honorable Nana.
The
minutes of the 4th of June. Any proposal for the adoption?
I propose, Chairman.
Honorable Nana proposes the adoption of the set of minutes for this 4th of June. Any seconder?
I second, Chairperson.
Honorable Van Wyk seconds. The minutes of The minutes of the 11th of June. Any proposer?
I propose, Chairperson.
Honorable Van Wyk proposes the adoption, and who's the seconder, please?
I second, Chairman.
Honorable Nana seconds. The last one is for the 18th of June.
I propose, Chair.
Okay, Honorable Matigizela, the seconder. There is a hand. Honorable Matigizela, is that your hand? Who proposed?
Yes, I've lowered it, Chair. It was a proposal for the adoption.
Okay. Any seconder, honorable members?
I second.
Second, Chair.
Oh, thank you, Honorable Mkhaga. Okay, that takes care of the adoption of the outstanding minutes. The meeting is adjourned, honorable members. Thank you so much for your patience. Thank you so much for your inputs.
Thank you,
A lot of
Chairperson.
our time was taken by the CPAs of Northwest. Now, there was a proposal for our visit to the Northwest. I want us to firm up that proposal so that the administration can actually begin to action that. But from where I'm seated, yes.
Can I suggest that the administration put some suggestions in terms of the date on the group, and then we can take it from there?
So there is a suggestion. It's very practical in terms, in the light of the constraint of time that we're having right now. Honorable Adams actually seconds that suggestion. So the committee will actually work out the logistics of that and then put it on our page, and then honorable members will then accordingly respond. Thank you, honorable members.
Excuse me,
Yes.
Chairperson. Can I quickly come in there? I've lost that proposal. I've lost a bit of signal when the proposal was made. Can you just repeat it for me? Thank you.
Yes, we were actually just firming up our proposals that was seconded, and the general consensus amongst members that we need to visit the CPAs that we were talking about today, and probably add other CPAs in the area and in the vicinity for the committee to visit. So the proposal was that the administration should actually work out the logistics and actually post them on our page, on the committee page, for us to look at.
Okay, Chairperson, thank you very much. Someone want to second it.
No, thank you so much. Honorable members, with that, yes.
I'm sorry, I know you are rushing to conclude. Chairperson, can I make an observation? Amongst other things that bedevil CPAs, I do understand these elections of CPAs are contracted out to would-be independent bodies. But in some of the complaints we receive is how elections were conducted in the first place. So I really would want to plant a seed amongst us as committee members. It's something that we can talk about later. That maybe as committee members, we should consider attending these AGMs as and when we can in our provinces, only to observe how these elections are conducted and do not interfere with anything else. It's just a thought. I don't know. It's possible, it's legal, or it can be done. Probably UDOC and the professional staff can advise at some point whether we can be allowed to have observer status in these meetings. Thanks.
Yeah. Well, thank you, Honorable Nana. And also the fact that why should the department look for agencies to actually run these elections when we have a well-established independent electoral commission in all provinces that can actually do that for free? Yeah.
Absolutely.
Honorable members, there is a suggestion, an idea from Honorable Nana that we could also, deploy ourselves as committee members to just go and observe the elections of these committees when they actually do take place. What is the committee's feeling about that?
Chairperson, if I may.
Yes.
Good day, because today I was a bit quiet, but now on this one, there is this problems that we see that the trust and the CPAs are experiencing. For instance, where I'm staying, the trust was under the administration of the Master of the High Court. Now, there is a lot of challenges and people are so divided. And sometimes as members, when you have observed the process and you are part and parcel of said communities and so on, it becomes an issue that it seems as if you are involved in all of these issues. So there is two ways to it. We can, yes, indeed, if you are not really very close to the situation, but also the issue of but in instances where there are so many challenges and fights and so on, it becomes very difficult for a member to get involved in it. So let us discuss this thing and actually work out something as to how we are going to deal with a specific issue. If we are deployed, maybe the committee must then deploy us, 1 or 2 members, to a specific area, but we must also make sure that we come with the information from our areas. I was just thinking to bring, because what I'm observing is so sad, but unfortunately it's what's happening. Thank you. Thank you, Chair.
Yeah, thank you. Perhaps we could deploy ourselves away from areas where we ordinarily reside, to avoid being contaminated with the local politics of the CPAs. I'm just throwing into the basket of ideas. But I think there is merit in us further interrogating this idea so that we actually fine-tune it and come up with a workable, kind of approach to this once we agree on the principle of us being part of the process of elections as observers. Honorable members, that being the case, the meeting is adjourned.
Thank you very much, Chairperson.
Thank you, Chairperson.
Thank you.
Thank you, Chair.
Thanks, Chair.
Thank you. Thank you, Honorable.
Nzwaki?
Recording stopped.